What's your emergency? I found out my granddaughter has been taken. She has been missing for a month. Her mother finally admitted that she's been missing. I need to find her. There's something wrong. I found my daughter's car today, and it smells like there's been a dead body in the damn car. Okay, what is the 3-year-old's name? Caylee, Caylee Anthony.
The Anthony family was a really typical-looking family. It was a cop, a nurse, their 2 children. And then the daughter had a baby. None of that is out of the ordinary. At the center of this case, we had a beautiful little girl, and she was missing, and it was a mystery, and we didn't know why, but what we did know was that mom was out partying while the baby was missing.
It's not a month that does not go by in my life that I don't have someone stop me on the street. And somewhere during that conversation, they asked, I wonder what really happened to Caylee.
Anytime a young mom is charged with killing her children, it makes the headlines because that is such an aberration, it's such a deviation from what young mothers are.
Casey, you don't realize that the whole United States is looking for our Caylee. Can you look up a little bit more? Raise your eyes up a little bit. There you go. So now, look straight up so I can look into your eyes, darling. Thank you.
She did appear normal. I think she's about as abnormal as she can get, but I think people wanted her to show some emotion. She never did.
Come to order, all right. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Caylee Marie Anthony. Does the state care to make an opening statement at this time?
Yes, Your Honor, we would.
You may proceed.
This is the case of the state of Florida versus Caylee Marie Anthony. However, it is time to tell the story of a little girl named Caylee.
George Anthony specifically recalls that at 12:50 p.m. on June 16th of 2008, George Anthony kissed his granddaughter goodbye and never saw her again. His daughter, Casey, left the residence on Hope Spring Drive with Caylee Marie Anthony. She told her mother that she was going to spend the night with a babysitter by the name of Sammy. You will learn there is no Sammy.
The body of Caylee Marie Anthony had been wrapped in a Winnie the Pooh blanket and thrown into a littered swamp like she was just another piece of trash. Caylee's death allowed Caylee Anthony to live the good life, at least for those 31 days.
Everybody had convicted Caylee Anthony in the court of public opinion long before she ever walked in that courtroom. And so Jose Baez and his group of attorneys had to undo that with these jurors who had all kind of heard about the case.
The media latched onto this case. My job was to save Caylee Anthony from the death penalty. If the case went south and for whatever reason a jury came back that she was guilty of first-degree murder, my job was to try to save her life. I believe we could have mitigated the death penalty.
How in the world can a mother wait 30 days before ever reporting her child missing? It's insane. It's bizarre. Well, the answer is actually relatively simple. She never was missing. Caylee Anthony died on June 16, 2008, when she drowned in her family's swimming pool. As soon as Casey came around this corner and went back, she saw George Anthony holding Caylee in his arms. She immediately grabbed Caylee and began to cry. Her death was covered up. This family must keep its secrets quiet. And it all began when Casey was 8 years old and her father came into her room and began to touch her inappropriately. Casey has a brother. When he was a teenager, he attempted to also touch his sister. Casey was raised to lie. That will help you understand why no one knew that her child was dead.
We were finding out all this dysfunction in this family, all these lies, all these secrets, all this backbiting that was going on in this family before Caylee even went missing. That Casey was willing to at least accuse her father and her brother of molesting her so that she could get out of jail for killing the baby. That's not a normal family. That's dysfunction.
Is your daughter there? Yes. Can I speak with her? Hello? Hello? Yes. Hi. Can you tell me a little bit what's going on? My daughter's been missing for the last 31 days. Who has her? Do you have a name? Her name is Zenaida Gonzalez. Who is that? Babysitter? She's been my nanny for about a year and a half, almost 2 years. Yeah, why are you calling now? Why didn't you call 31 days ago? I've been looking for her and have gone through other resources to try to find her.
When you first met Ms. Anthony, can you tell the jury how she appeared?
She always seemed like she was having a good time.
Did you ever see her distraught?
No, sir.
Depressed?
No, sir.
Scared?
No, sir.
She was partying and having a good time.
Did she tell you that her daughter was missing?
No.
Did she ever tell you that her daughter had been kidnapped?
No.
That she was missing?
No.
No. No.
No, sir.
No, sir.
Did you ever ask the defendant where Caylee was?
Yes, sir, I did.
What did she tell you?
And that she was at Disney World with the nanny.
She said she was with the nanny.
She told me that she was spending the weekend at the beach with the nanny.
Did Caylee Anthony ever tell you that her daughter was missing?
No, sir.
That she was looking for her?
No.
That she needed any help?
Nope.
No, sir.
Did she ever cry?
No.
Did she ever act scared?
Nope.
At any time during this night, did she ever tell you that her child was missing?
No, sir.
Once the jury was there, I think they hated Caylee Anthony. Well, you could tell. They would glare at her. They didn't like her. They would shake their heads when they'd see pictures of her dancing on tables and everything. Nobody knows where she is, but all we know is that Mom, Caylee Anthony, was out partying when she should have been looking for her daughter.
How come everybody's saying that you're not upset, that you're not crying, that you show no caring of where Caylee is at all? I'm not sitting here crying every 2 seconds because I have to stay composed to talk to detectives. You have to tell me if you know anything about Caylee. If anything happens with Caylee Casey, I'll die. You understand? I'll die. If anything happens to that baby. Oh my God. Calling you guys? A waste. Huge waste.
We're talking about cold, hard evidence. And he could get up here and lie all he wants and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here or whether it's myself.
Objection. Approach the bench.
This case was the craziest case I've ever been involved in. It was like the Hatfields and the McCoys, and they were using profanity at each other just in the regular course of business.
How is the good faith basis relevance of that? That is not the question counsel asked, and he darn well knows it.
Anything else, folks?
The prosecution and the defense of the Caylee Anthony case couldn't stand each other. Sometimes nobody could see it but those of us in the gallery. Watching them backbite each other, watching them snip at each other, watching them roll their eyes while somebody on their own team was up there, cross-examining a witness.
Approach the sidebar and cut the comments out. The level of tension in this one here was probably, it was a 10. My major concern was one, courtroom control. What is that symbol that you are projecting with your fingers?
Using my middle finger, and I am sorry.
Okay, and what does that mean, sir?
The F word to someone.
At this time, I will adjudge you to be guilty. I will sentence you to 6 days in Orange County Jail, or he will be remanded. I made it loud and clear that I was not going to tolerate anyone breaking any rules, be it the prosecution, the defense, or the public.
I've never seen so many people so invested in the outcome of a criminal case. Everybody had adopted Caylee Anthony as their own, and they wanted to avenge her death in some way.
They said that the person that you dropped Caylee with doesn't even exist. Because, oh, look, they can't find her in the Florida database. She's not just from Florida. They need to look up her information in a New York database, in a North Carolina database, other places that she's lived outside of Florida.
On Monday, June 9th, 2008, between 9 a.m. and 1 p.m., I, Caylee Anthony, took my daughter, Caylee Marie Anthony, to her nanny's apartment. Zenaida Gonzalez has watched her for the past 1.5 to 2 years. However, after reaching the apartment, I realized that neither Zenaida, Caylee, or either of her 2 roommates were home.
Did you determine whether or not an individual by the name of Zenaida Gonzalez had been the last occupant of that apartment?
I researched the prior occupants of that apartment, and it was not Zenaida Gonzalez who occupied it.
I think it's really simple. I think that she wanted a party. I think that she had looked at different ways to knock the child out, and maybe she'd done it before successfully. That Zanny the nanny reference, you know, like Xanax for the baby. That's really the keeper of the child.
Everything that's coming out of your mouth is a lie. Everything. So I can look at you in one of a couple of ways. I can look at you as a person who's scared, who's concerned, or we can look at you as cold, callous, and a monster who doesn't care, who's just trying to get away with something something bad had happened and trying to cover it up. Or we're not stupid, okay? And what you're doing right now is you're treating us like we're stupid.
It would have been very hard for Caylee Anthony to take the stand because Caylee Anthony had lied so many times. So what would she do under cross-examination? The defense team knew that Caylee couldn't take the stand.
Casey? Mom. Hey, sweetie. Oh, I just saw your nice little cameo on TV. You don't know what my involvement is and stuff? You're not telling me where she's at? Because I don't know where she's at. Are you kidding me? I don't want to talk to you right now. Forget it.
The woman on the tape was someone who was completely in charge. She would be demanding, she would speak up, she would challenge them.
I called to talk to my mother, and it's a waste.
They had to do something to counter all the video that we were seeing in court of her yelling at her parents and swearing at her parents. At the beginning of the trial, she was a little bit more defiant. She was outraged that she was on trial for this. And at some point, we started seeing Caylee Anthony wearing blouses that came up to her neck so that, you know, with a big bow on it to look as innocent as possible. They even lowered her seat so she looked smaller than everybody else on the defense table because what they were trying to do was show this is a girl who could never kill anybody.
Now, what happened to Caylee?
I don't know.
Sure you do.
I don't know.
Something, or I'm guessing something bad happened to her some time ago and you haven't seen her.
She's with someone else.
No, she's either in a dumpster right now, she's buried somewhere.
I'm a meter reader with Orange County, and I had the route today that included the Anthony's home. I noticed something that looked white, and there was like a gray bag down in there. I'm a meter reader with Orange County, and I had the route today that included the Anthony's home. And there's a lot of swamp back in there. Well, back behind one of the trees down there was a gray bag, and then a little bit further up than that, I saw something white. And it would be on the right-hand side that I saw what I saw.
There have been significant skeletal remains located late this afternoon. The skeletal remains are still the consistency of a small child,
The discovery comes a week after a child's skull was found in a nearby wooded area, blocks away from where the 2-year-old lived with her mother and grandparents.
We have secured the Anthony house. We've also exhumed the remains, and that has been transported to the medical examiner's office.
Did you receive results from the FBI as to the identification of the remains?
Yes.
And did that laboratory identify the remains as that is Caylee Marie Anthony?
Yes, they did.
They found duct tape. They actually did a graphic of the 4 parts of the skull and put it back together for the jury so that they could see the duct tape around the child's face.
Do you have an opinion as to the manner of death in this case?
It is a red flag that when a child is not reported immediately to authorities, that's something we look for foul play. Besides the delay, besides the being found in a field decomposed, would be the duct tape somewhere located on the lower half of this face. There is no child that should have duct tape on its face when it dies.
Based on the skeletal condition of the remains, can you render a medical conclusion on the cause of death?
What I put was homicide of undetermined means.
Well, someone just said that Caylee was dead this morning, that she drowned in the pool. That's the newest story out there. Surprise, surprise.
There's the proof that she could easily get outside. There's the proof that she was big enough and strong enough to open the door. You can't get anything better than that. And look at how soft Cindy is holding her or touching her. She's on her own. And look at what Caylee's doing. Caylee's diving into that water.
When the defense gave their opening statement and said Caylee Anthony was found face down in the pool, what the prosecution should have done at that point was to say, when you find your baby face down in the pool, you call the police, you call an ambulance, because you don't know if she's dead or not. And if you decide then to put duct tape around her and wrap her body in a trash bag and throw it in the woods, that is aggravated child abuse. That's a 15-year charge. They wanted a first-degree charge so much that they didn't bother to explain it's child abuse.
George began to yell at her. Look what you've done. Your mother will never forgive you, and you will go to jail for child neglect for the rest of your freaking life. Why did George do this? Why didn't he call in?
You started off with pointing the finger at George, the father. You start questioning his credibility, his believability, so you would discount his particular testimony. And what they did was they created a ball of confusion.
Were you present in your home when Caylee Anthony died?
No, and when I heard that today, it hurt really bad. Because if I would have known something would have happened to Caylee, we wouldn't be here today.
Did you dispose of the body of your granddaughter?
No, I did not.
Mr. Baez, what would you see to determine whether someone drowned?
Well,
if a body's not found in a pool.
To answer the court's question, I believe, was what record evidence is there that the victim drowned? The answer is none.
Casey is staying with her boyfriend, Tony, and sadly, Caylee is in all likelihood in the trunk.
It was an odor consistent to what I'd smelled in the past when it comes to decomposition.
I am a forensic chemist examiner,
Canine handler,
hair and fiber examiner, professor of anthropology,
geologist, forensic examiner, forensic toxicologist, computer examiner,
human identification laboratory.
in the latent print operations unit.
My specialty is analytical chemistry.
Insect evidence.
Did you find any hairs that showed evidence of apparent decomposition?
One of the items showed, had a hair that exhibited characteristics of decomposition.
I think you had a death scene where Caylee had probably perished. It was the trunk of that car. And that's why she abandoned the car. And that's why she lied so much. And that's why she waited so long. And the fact that she waited so long and saying anything meant that child was so decomposed they didn't know the cause of death.
Have you ever had the opportunity in your 30 years in the towing business to come across a vehicle in which there had been a dead body?
Yes, ma'am.
Were you able at that juncture to make any connection?
It was an odor consistent of what I'd smelled in the past when it comes to decomposition. It's not a smell that you forget.
Based on my 23 years experience, my opinion is that it was the smell of human decomposition.
That trunk smelled like a dead body.
The trunk of my daughter's car smelled like human decomposition.
He was a cop. He knows what a dead body smells like.
There's something wrong. I found my daughter's car today, and it smells like there's been a dead body in the damn car.
Casey's mother was a nurse. She knows what a dead body smells like.
When someone dies, the gases that are produced from the bacterial metabolism have really no place to escape. And we began monitoring which chemicals are being produced.
There was one expert who supposedly had a detector, a sniff test detector. It was the most ridiculous thing I had ever seen.
Do you have an opinion as to whether there was a decomposing human body in the trunk of that car at some point?
I do have an opinion on it.
And what is that opinion?
I can find no other plausible explanation other than that.
You know that your findings are not generally accepted in the scientific community, do you not?
Objection.
Sustained.
Strike.
Granted.
He was arguing that he could somehow sniff the air in a person's car and determine that it was the result of a decomposing human body. They put this what I would call a junk scientist on the stand to testify.
And the significance of the evidence, such as the smell of death, what that really meant, the fact that you had decaying hair in the trunk of the car. I know the defense wanted to call some of it voodoo science. I call it cutting-edge science that basically had support in the literature and scientific background.
What chemical compounds did that initial evaluation show?
The large peak was identified as chloroform because the chloroform was shockingly high, unusually high.
The thought was that perhaps Caylee had used chloroform just to put her to sleep and so she could go out. I heard, and don't know whether it's true or not, that was done from time to time, and maybe in earlier years when people didn't understand how dangerous it was, and that she accidentally killed her.
Any clues or anything that I should focus on at the house? Mom's house, your house?
Outside of maybe stuff on the computer, nothing I can think of.
On the computer.
They, late in the trial, got into some of the internet searches that were done, and then they tried to attribute them to Caylee Anthony. She had researched chloroform.
Were you asked to perform a keyword search for chloroform?
Yes, I was. In this case, with the chloroform keyword search hit, we were able to recover a complete internet history from Mozilla Firefox.
All right, so if the user at the time typed in how to make chloroform?
Yes.
The prosecution said that Caylee Anthony used chloroform to kill her child. But I sat there in trial the entire time, paying attention to every word. I still don't know, how do you make chloroform? I have no idea. What are the ingredients? Did Casey ever buy those ingredients? Do you have any proof that she did? We never saw that. So that's a big piece of the puzzle missing.
In our case, there has been no evidence presented that Caylee Marie Anthony used duct tape for any purpose, that she used chloroform ever for any purpose, and that in any way, in any capacity whatsoever, she contributed to the cause of death of this child. It is forcing, guessing, and speculation.
Jurors don't know anything. You're painting a picture on a canvas. Everything that you want them to see, you got to paint it in that picture. The defense not only did that, but they did something that most people really didn't notice they were doing. They were throwing out reasonable doubt in every corner that they could.
You know, of course, that sex with a child under the age of 12 years old is life in prison, don't you, sir?
Relevance.
Sustained. Ms. Burdick, you may proceed.
Casey's car was in Orlando.
Yes, ma'am.
Once the car is in the garage, do you access it in some fashion?
Yes, Casey's purse was on the front seat, and that Kaylee's baby doll, her favorite doll was in the car seat, like it was sitting where Caylee would have sat.
I think Cindy Anthony was a compelling witness. There were times where she burst into tears on the stand. She was doubled over in agony as she's listening to the 911 calls. And I think that the jury, their heart went out to her.
When you look at the dynamics of the testimony of George and Cindy Anthony, you really look at the ebb and flow of that particular trial.
Can I have a break, sir? Can I have a break?
A drink? Okay, let's take a 5-minute recess.
All right, jury.
Here you have these loving grandparents who would move heaven and earth for their granddaughter. But also you have them in the role of being the parents of the person who's accused of murdering this child. You got Cindy faced with this proposition. Her testimony not only could lead to her daughter being found guilty of murder in the first degree, but it could also lead to the imposition of the ultimate sanction of death.
That's both George Anthony. In January, late January of 2009, you attempted to commit suicide.
The defense didn't try to throw George Anthony under the bus.
Did you, sir?
Yes, sir, I did.
The defense threw him under the bus, backed up the bus, ran over him again, backed it up again, and ran over him again.
So you were drinking beer and blood pressure medication?
They crucified him in court.
You have to be specific with me, sir. Give me a date, and I'll answer.
I'm giving you a date, but my
no, sir. You are badgering me. You're trying to get me upset, sir. I'm just asking you. Treat me with a little bit of respect, and you'll get respect back. That's all I'm asking.
Mr. Anthony, would you like to answer my question now?
Objection to counsel's commentary.
And I don't think that the jury necessarily believed what they were saying, but George started to show this defiant side of him.
Mr. Anthony, do you know a woman by the name of Crystal Holloway?
I know her by that name and also another name.
Okay. Did you have a romantic relationship with her?
No, sir. No. To me, that's very funny.
Very funny.
Yes, sir.
George Anthony is now a cop with a chip on his shoulder testifying, and he looked like, yeah, he probably could have done something wrong, which I think came directly from him being accused of something that he says he didn't do.
The defense calls Crystal Holloway. Did you develop a relationship with Mr. Anthony?
Yes, sir, I did.
Was this an intimate relationship?
Yes.
Did there ever come an occasion where you had a heart-to-heart conversation with George Anthony as to what happened to his granddaughter?
He was sitting on my couch, and he had said it was an accident that snowballed out of control.
Cross-examination?
How much money did you get from the National Enquirer for selling your story?
$4,000.
$4,000.
You may be seated. All right, gentlemen.
You know, of course, that sex with a child under the age of 12 years old is life in prison, don't you, sir?
Relevance.
Sustain.
You're aware of the possible penalties of child molesting, don't you, sir?
Objection. Relevance.
Sustain.
You, of course, would never admit to molesting your child, would you, sir?
Objection. Argumentative.
There was an insinuation here, I think, that perhaps George had somehow been responsible in some way for the death of Caylee, and that Casey's reluctance to turn on her father had something to do with the fact that he had been abusing her.
Sir, I would never do anything to harm my daughter in that way.
Only in that way.
Objection.
Sir.
Sustain.
You don't talk about a fact if you know that there is not a way to prove it. And generally, the only way to prove something is through testimony of an individual. I don't believe that Jose or Caylee intended on calling Casey as a witness. So it was unclear to me how they were going to prove up those accusations.
I do think that the defense did a really good job of confusing the issues. Maybe it was George Anthony. Maybe it was somebody else. We don't know. Maybe it was the meter reader.
Were you aware of there being a reward offered for the finding of Caylee?
And by the time we were done with 7 weeks worth of trial, everybody looked guilty.
The prosecutors set for themselves a very tough bar in seeking death. Every piece of evidence is weighed under a microscope by the jurors. If there's any flaw or any missing link, no matter how apparently insignificant it may be, it's not insignificant to a death penalty jury.
I think that you'll see that despite the outcry, the notoriety, the emotions, so forth, the case is not here.
State recognized presence of the jury.
We do, Your Honor.
Good afternoon, ladies and gentlemen of the jury. Have you reached a verdict?
Yes, sir.
And each count was being read. What went through my mind was, holy this is never going to go away. We are going to be talking about this in 5 years, 10 years, 20 years.
Ladies and gentlemen of the jury, the attorneys now will present their final arguments. The state may proceed.
Thank you, sir. When you have a child, that child becomes your life. This case is about the clash between that responsibility and the life that Caylee Anthony wanted to have. She took her life and she put her in the trunk and forgot about her. And she disposed of her body in a swamp. It is a trip down the rabbit hole into a bizarre world where men who love their granddaughters find them drowned and do nothing. This is the world that the defense invites you to occupy. Caylee Anthony is guilty of murder in the first degree.
I have to tell you that I probably think you have more questions than you have answers. It is extremely reasonable that she could have drowned in the pool. And that's where the state fails. They must rebut each and every reasonable hypothesis of innocence. They cannot rebut this. They're hoping they throw enough against the wall and see what sticks. Right down to their cause of death. 1 week it was chloroform. Today it's duct tape. I'm not proud of the way Caylee behaved. I don't think anybody here can justify her actions, but they do not constitute murder.
The defendant is not required to present evidence or prove anything. Never forget, no matter what the issue is, they have all of the burden, and there is none over here.
Members of the jury, I would like to thank you for your attention during the trial. Please pay attention to the instructions I'm about to give you. The judge's job is to give the standard jury instruction. It's the prosecution or the defense to request a special instruction. One, would a special jury instruction indicating that proving how she died was not an element of the crime to be proven, I think that may have made a tremendous difference. I had already prepared that instruction, but when I got no request for that, I didn't figure it would come from the defense. I figured it would come from the state, but they never asked.
They needed an instruction on how they can convict on a lesser charge, because Casey was looking at murder one, but she was also looking at basically negligent treatment of a child. Super easy to prove, but they didn't give that.
Members of the jury, you may retire now to begin your deliberations.
Cheney, do you think she's going to walk today? I'm just asking for a prediction, sir.
Keep moving, please. Keep moving. Keep moving.
Well, into the show here, Cheney.
Keep moving. Clear the way. Clear the way. Clear the way. Clear the way. Clear the way.
It has been brought to my attention that the jury has reached a verdict. State?
The state's ready to proceed, Your Honor.
Defense?
Defense is ready.
Let's return to jury.
It was totally quiet in the courtroom, and the jurors start coming in.
Good afternoon, ladies and gentlemen of the jury. Have you reached a verdict? Would you hand the verdict form to the court deputy, please?
There was this tension in the room. It was so quiet in that courtroom that you could hear a pin drop, except we could hear the helicopters from the local news stations circling around overhead.
I actually read the jury verdict twice to make sure that my eyes were not playing tricks on me. Will the defendant rise along with counsel? Madam Clerk, you may publish the verdicts.
As to the charge of first-degree murder, verdict as to count 1, we, the jury, find the defendant not guilty.
So when they said not guilty, I could hear 25 floors below the crowd outside. I could hear them gasp.
I mean, they just let a baby killer, an obvious baby killer, out of jail. Murderer is walking out of this courthouse as we speak. Justice for Caylee! Justice for Caylee! Justice for Caylee! Justice for Caylee!
As to the charge of aggravated child abuse, verdict as to count 2, we, the jury, find the defendant not guilty. As to the charge of aggravated manslaughter of a child, verdict as to count 3, we, the jury, find the defendant not guilty.
Then each count was being read, and she was being found not guilty and not guilty. What went through my mind was, holy this is never gonna go away. We are gonna be talking about this in 5 years, 10 years, 20 years.
As to count 4, we, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment.
I'm watching Casey. She's standing there. She's sort of breathing heavily. And as each verdict is being read, I can see her shoulders are getting a little less tense. I can see that Jose's shoulders are getting a little less tense. And I can see the prosecution getting more and more tense and more angry. And the cops who investigated the case were sitting 2 rows behind me. And one of them walked out and said to the other, that was some right there, because they were furious.
Appeal! 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 Appeal!
One of the jurors indicated that the reason she found the defendant not guilty was because the state could not prove how the child died.
I thought it was a travesty. I felt like the prosecution hadn't adequately explained circumstantial evidence, because this was a circumstantial evidence case.
I wasn't surprised. I was surprised at the total acquittal. I think as prosecutors, we should have put everyone on alert. Be very careful before you recommend prosecution on a death penalty.
Had they charged Caylee Anthony with manslaughter or second-degree murder? Ultimately, the case may have resolved in another manner.
I think she beat the system. Caylee Anthony beat the system. She sat there trying to look like, you know, a choir girl the whole time and wringing her hands and everything else. She lied to everybody. People hated her. People still hate her.
There's not but two people that know what happened. One is dead, that's Caylee, and the other person is Casey. Maybe one day, and for the sake of that child, she will answer that question, what really happened?
If I could ask Caylee Anthony a question, I wouldn't ask her what happened to Caylee. I'm not going to get the truth from her. I would ask her, how do you sleep? How do you sleep each night? What haunts you, Caylee? What did you do?
She was the most hated woman in America when her 2-year-old daughter, Caylee Marie, disappeared. She was public enemy #1 when she blamed a fictitious woman named Zenaida the nanny for taking her daughter. She was seen as a narcissistic, evil woman when the remains of her daughter were recovered, tossed into the woods around the corner from her house, wrapped in trash bags with duct tape still in her hair. She was seen as the worst of the worst by prosecutors when they charged her with capital murder, facing the death penalty. But she was seen as not guilty by 12 jurors from Pinellas County, Florida, after a trial where the overwhelming majority of court watchers believed she was a murderer. Now, 11 years after that verdict, she will do what she didn't do at her trial: answer questions about the death of her daughter. It's all part of a new series on Peacock entitled Caylee Anthony, Where the Truth Lies. Tonight, we take a look at the convicted felon and ask, how many more lies can she tell in a 3-part docuseries?
I'm Vinny Politan. Thanks so much for joining us tonight here on Closing Arguments. And as we begin this program in this hour tonight, I want to apologize to everyone. I'm doing that up top. Why am I apologizing? Because I'm going to have to do something that I usually don't like to do. And it's utter 2 words that I don't like to utter. And for those of you who've watched me through the years, you know what I'm about to say. Those 2 words. Caylee Anthony. All right, I did it. I'm going to have to do it because it's part of my job tonight. So I'm going to be breaking those rules. I'm breaking my own rules tonight by talking about Caylee Anthony. I've already apologized to you. Now let's get to why we're talking about Caylee Anthony 11 years after that moment down in Orlando, Florida. First of all, you may recall during that trial, something came out. Evidence during a pretrial hearing about money that was paid to Caylee Anthony by the media. ABC paid her $200,000. It was on the record. It was in court. It happened. They apparently were licensing or purchasing some photos from Caylee Anthony. They gave her $200,000. Now, she didn't keep the money. She used that money to pay for her lawyer, Jose Baez. We learned that inside the courtroom as well. But it raised a lot of controversy because people were a little upset about the fact that Caylee Anthony could profit from her situation. Now, after the verdict, she's found not guilty, so everyone's wondering who's going to get the interview. Who is she going to speak to? And there was a lot of public backlash. Nobody wanted to hear from her, primarily because members of the public assume and presume when you speak out, when you're someone like Caylee Anthony on television in that big interview, you're getting paid, right? And people thought that would happen here because ABC had already paid her $200,000. So because of that public backlash, the media backed off. There were interviews that were scheduled that were canceled. And we never heard from Caylee Anthony after that not guilty verdict. Now, she's about to speak again for the first time. That's the big news tonight. But we've already heard her story. She didn't say it, but it was her attorney, Jose Baez, who already told her story. Jose Baez, if you'll recall, I mean, there wasn't really evidence of the story, but he talked about the fact that little Caylee Marie Anthony drowned accidentally in the pool. She was found by her grandfather, George, who found little Caylee Marie and then went in and screamed at Caylee Anthony that she was going to get in trouble. You're never going to hear the end of it. And then apparently George Anthony, according to Caylee Anthony's attorney, who is speaking for her, then George Anthony gets rid of little Caylee Marie. And that's her story. That was the story during the trial. Caylee Anthony never said it, but her attorney did, and then there was no evidence to back any of it up. So is it true, is it not true? I don't know. But everyone is talking now because of Caylee Anthony getting ready to talk, right? All of this after this moment, I'm going to play. Again, I've apologized already, but let me show you one more time what happened, in case you don't believe it, inside that courtroom many years ago.
As to the charge of first-degree murder, verdict as to count 1, we, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, on this 5th day of July, 2011, signed foreperson.
Well, counsel.
Still hard to believe. Still hard to believe, not guilty of the first-degree murder and the lesser-included accounts, not held responsible for the death of her daughter. Unreal. Now let's get to the big news. Today, Peacock announced a limited docuseries that's going to be released later this month, where Caylee Anthony is apparently sharing her story. Take a look at some of the newly released trailer for Caylee Anthony, Where the Truth Lies.
A, B, C marker, soft sticks.
Why talk to me now when you're not getting creative control?
That's a great question. Why are you talking now? I have a question. Did you get paid? That's to me, that's the most important question with all of this. Are you getting paid for that interview? Are you getting paid for any material that you provided to the docuseries, like some pictures or photographs or videos or recordings? Because if so, I think the public should know. The public should know if Caylee Anthony's getting paid for this whole thing before they make the decision on whether or not they should watch it. All right, let's bring in tonight's guests. Oh yeah, joining me in Orlando, Florida tonight by phone, retired 9th Judicial Circuit Judge who presided over the case, America's Judge, the Honorable Belvin Perry. And in Seattle, Washington, trial attorney Ann Bremner, who was with me in Orlando when all of this happened, when all of it happened. Judge, let me begin with you. How are you tonight? And your reaction to that woman, Caylee Anthony, apparently finally sitting down in front of a camera to tell the world what really happened.
First of all, good evening, Vinny. I'm doing fine. My first reaction is, will we receive another pack of lies?
Well, it's only a 3-parter, Judge, so that's my question tonight. How many lies can you actually tell in a 3-part docuseries? Now, Judge, just to remind everyone at home, I mean, she was convicted by that jury of lying, wasn't she?
That's correct.
So,
giving false information to police officers.
That's right. And part of the false information, I remember the whole story where she pretended to work at Universal Studios and was like, bringing the police officers to her office, and then, finally broke down and said, I don't actually work here. Ann Bremner, let me ask you off the top here, your reaction to this announcement, this moment that Caylee Anthony, in front of a camera, without creative control, they're making that very clear. She doesn't have editorial control over the final product, but telling her story.
It's just outrageous, and why now? I mean, is it because of all this true crime, things that we see like Dahmer, I mean, on Netflix? She's just off the top, especially I think she's getting paid for sure. I agree with you, Vinny. And the question is how much? And so what? If she doesn't get creative license for the whole piece, she can say whatever she wants to say and say she's innocent and tell some more lies and do exactly what she did in the trial. Zanny the nanny, the child's missing for a month. Everything about Universal Studios. And when she finally got caught in a lie, and she couldn't go any further, she go, oh yeah, that's a lie. Remember, they were imaginary friends that Mr. Baez talked about in closing. So I just think it's outrageous. It's been a lot of years since we covered that trial. It was like a twilight.
Yeah, for me, whether she speaks or doesn't speak, I would never want to stop someone from speaking. I've always wanted to interview her because I would cross-examine her, ask her the difficult questions. I don't know the format of this whole thing. Hopefully there are some tough questions that are asked during the whole thing. But Judge, let me ask you, what are some of the questions that you would have for Caylee Anthony if she was going to sit down and say, hey, I'm ready to tell my story, I'm ready to answer some questions?
The first question I would ask her is what happened to your daughter? Second question I would ask, do you back the defense's theory that your daughter drowned in the pool and your father buried her in a wooded area? That's where I would start.
In the opening statement of the trial, that's really when I said everything was turned upside down by Jose Baez during that opening statement, because he put the whole thing about Caylee Marie being missing for 30 days and said, no, she wasn't missing, she was dead. And Caylee Anthony knew she was dead. Judge, wasn't there a whole bunch of pretrial hearings in the case, though, involving other potential suspects and what sort of information would be permitted and what sort of things would be able to be used as evidence when it comes to whether it was Roy Kronk, the meter reader, or Caylee Anthony's boyfriend at the time, DJ Anthony, or her fiance at the time? Wasn't that part of what was litigated before the trial, before we heard the story that no one else was responsible, that it was an accident?
First, the finger pointing start with the meter reader. They tried to lay blame on him during some initial hearing. And then there's a second phase dealing with the fact of the father may have been responsible. And then she started to point finger pointing at some of her friends. So she was all over the place in terms of theories.
And to me, that is such an important fact that kind of gets lost in the sauce, right? For those of us who followed the case and obviously saw everything that happened working up before the trial, if in fact this little girl had drowned in the pool and it was an accident from the beginning, none of that would have been necessary. I mean, Roy Kronk becomes virtually irrelevant. The boyfriend becomes irrelevant. The fiance becomes irrelevant because you knew all along exactly what happened, and it was an accident, and it was Grandpa who got rid of Caylee Marie. That's why I never believed that story. But it really changed the dynamic of the trial, Judge, didn't it?
It totally changed the dynamic of the trial. And one of the interesting things about the whole, was that they had several theories. Believe the drowning. If you don't believe the drowning, then believe reasonable doubt. And the bottom line, the jury got hung up on the fact that the state could not show how Caylee died.
And from my perspective, that was a problem. I mean, that was a problem for prosecutors, but we've seen prosecutors win cases when the victim is never recovered. The victim is still missing. So not being able to prove specifically exactly how she died is not the end of the game in prosecutions, but obviously it makes it much, much more difficult. And the reason, Judge, as I recall, that they had so much trouble with that is because it took so long to find her because of the job by the police officer who was originally called after Roy Kronk found her in the woods the first time, before the torrential rain, before all the animals and the bugs attacked Caylee Marie's remains. Roy Kronk found her, called police, but the officer that showed up didn't go into the woods. He was scared. He slipped in the puddle and went home.
And he saw a snake.
Well, that's right, the snake. There was a snake there. And
But then there's one point.
Go ahead.
The state never requested a special instruction indicating that the cause of death was not an element to be proven. And that's how the jury got hung up.
That is so true. That is so true. If they got the instruction that, listen, prosecutors do not have to prove to you beyond a reasonable doubt exactly how she died, ladies and gentlemen, they can still prove the case, the elements of the crime. That's a big point. All right, Judge Belvin Perry is with us tonight, folks. We're talking about what just happened today. Peacock has a new 3-part docuseries. Caylee Anthony apparently telling her story.
She took her life, and she put her in the trunk and forgot about her. After a couple of days, she couldn't forget anymore, and she disposed of her body in a swamp. These are the facts that you have heard, and these are the facts that prove, beyond a reasonable doubt, that Caylee Anthony is guilty of murder in the first degree.
At the end of the day, when everything is said and done, the one question will never be answered. The key question in this case will never be answered. It can never be proven. And that is, how did Caylee die?
Those were little pieces of the closing arguments, and in that case, the lawyers made a difference. They absolutely did, because at the end of the day, when we spoke with the jurors, they didn't like the prosecutor and they loved the defense attorney. And it made a difference. It made a difference, you know? You don't like the person who's delivering the message, you're less likely to believe them. And that's part of what happened in the case with Caylee Anthony. By the way, so the big news today, Peacock, brand new mini docuseries, 3 parts, and apparently it's Caylee Anthony telling her story. Now, for those of you just joining us, I apologized off the top of the hour about everything that we're doing now. I already apologized, so I'm not going to do it again. But we have heard from her in the past. She has spoken. Remember this?
Then again, I want to bring up this thing about you being the boss. You're the one that can control everything. You're the one.
No,
that can make the
Dad.
decision.
Please.
Sweetie,
I'm completely.
I'm not trying to get you upset. I'm trying to talk to you.
No, but I am upset now. I'm completely upset. One, the media is going to have a freaking field day with this.
No,
I wasn't even supposed to take this. Let me speak for a second. Dad, I let everybody talk.
Okay.
They're not releasing it. Well, I hope not. I'll keep saying whatever I have to about the police, so they don't let it go. Can someone let me? Come on.
Casey, hold on, sweetheart. Settle down, baby.
Nobody's letting me speak. You want me to talk? Then
all right,
give me
I'll listen to
3
you.
seconds to say
Go,
something.
sweetheart.
I'm not in control over any of this because I don't know what the hell's going on. I don't know what's going on. My entire life has been taken from me. That's really, really sad that I literally have nothing right now.
Well,
nothing.
None of us have anything right now, Casey.
You guys have each other. You're sitting next to Dad. You still have Lee. You have access to our community, to our family and friends, to our house. You're taking for granted the fact that I have no one to comfort me but myself.
Me. That was Caylee Anthony. No mention of her daughter in all of that, by the way. Fascinating. But that was really most of what we heard from Caylee Anthony. But now with this new series, apparently she's going to speak, give her story. Still with us tonight, folks, the judge who presided over the case, the Honorable Belvin Perry, still with us by phone down in Orlando, and Ann Bremner, who was with me in Orlando when all this was happening, is in Seattle tonight. So, Ann, what do you expect her to say? What do you think she's going to actually say? Will it be consistent with that opening statement that Jose Baez made?
Yeah, she could do that, Vinny. I mean, and I always wondered why the state didn't just move to strike that and just go after that because they never proved any of it. Or she could simply say, you know, that she was a victim of the lawyers and that Cheney Mason, you know, was another lawyer in the case, you know, and she didn't really believe any of that, but she's coming clean now. She didn't kill her daughter and she wants to, you know, have a great life. I mean, she's such a manipulator. She's such a liar. I mean, she could come out with a whole news story about it and maybe tell us where to find Casey or Caylee. You know, she'd like say, well, I know where she is. I mean, that's how delusional she's been all along. I don't know how His Honor, the judge, it's an honor to be on with you, sir, put up with this case. I mean, it was just, bless your heart, you know. But yeah, I mean, who knows? She's a woman of many stories.
Judge, let me ask you this, because a lot of people are thinking at home right now, well, what if she says something that's different than what her lawyer said in court? What if she admits to something? I mean, nothing can happen to her based upon anything she says, can it?
Nothing can happen to her because the principle of double jeopardy. Then what is going to be interesting is, remember the last time she said something. She said the last time she saw Caylee alive, she was doing fine and she was with allegedly a babysitter. We will not know what will come out of her mouth. I mean, it's a great possibility. She may throw her attorneys under the bus, or she may come up with some wild theory. She has nothing to lose. And like you, Vinny, I want to know, was she paid for this interview?
Yeah, and we have not heard that. We know there was a press release that went out that talked about editorial control, which is one part of the equation. But the much larger part of the equation, which is what the public backlash was all about, was someone actually paying her for her story. And for all these years, I was convinced that's why we never heard it, because no one was ever willing to pay for it. Everyone wanted to hear it. I mean, any journalist would want to interview her, but no one wants to be the one giving her money for it. And it's going to be interesting to see if they address that issue, whether it's Peacock or the producer, the director, the showrunner, whoever's going to speak out about this, if they will address that particular issue. Maybe it's addressed even in the program itself. I'm not sure. So what's the lingering questions that you have, Ann Bremner? If you had a moment to interview Caylee Anthony, what are some of the questions you'd want to ask, Ann?
I'd ask her how she killed her daughter. That's where I'd start.
Objection, leading question.
Like, that's the thing the jurors couldn't get. Let's just tell us now, you know, after all these years, how'd you do it? When'd you do it? Why'd you do it? And then I'd be done. And she'd lie on every question. One other thing I was going to say, Vinny, on the checkbook journalism, wasn't that a licensed photo of that snake that was $250,000? I think we talked about earlier. Back in the days when they would license photos to give money for someone to give an interview. Which left such a bad taste in everybody's mouth with someone like her. I mean, she was just despised. Yeah, exactly.
Judge, let me ask you, it's been 11 years now since the verdict. Are people still approaching you? And if so, what is the public temperature? Has it cooled down at all from people who want to talk to you about the case?
The people that I run into basically feel that she was guilty and that she got away with murder. But they want to know what really happened. But they also recognize they can't believe a word that she says.
That's been proven. Ann Bremner, there's always the comparison because the trials happened, within a few years of one another, of Jodi Arias, who was also a notorious liar. But I always said, you put those two next to each other, Caylee Anthony, so much better. She can lie on the spot and change direction. Jodi Arias, you recall in the interrogation room, she would have to take a moment to think and try to figure it out. It just came much more natural to Caylee Anthony. She's just able to spew it, which to me is going to be the fascinating part of watching this, to see exactly what she's going to say and then have our body language experts watch the show and come on my program and tell me what they saw and what they heard, because to me, there's got to be some indicators. I went on my cell phone and then I binge watched Caylee Anthony for 3 hours. For 3 hours. And let me go through my little take on what I experienced during, I guess it's more than 3 hours, 3 episodes, during this all-night journey last night. First of all, the way I would describe this docuseries is ridiculously bizarre, because it starts as almost a love story between a woman accused of murdering her child and her defense team. Although part of this love story, and it's not a romantic love story, I mean a love story like, this is my family now and they have done all of this for me and we are joined forever, with the music playing in the background. And it's bizarre, because beneath all of that, and the entire premise of this show is that she tells us in the docuseries what really happened for the first time, something that she didn't even tell to her own defense team. I mean, she's facing the death penalty. If she loses the trial, she goes to death row. That's where prosecutors want to put her. Her new story, she's like 100% innocent, and she knows exactly who is responsible, yet, for some unbeknownst reason, she doesn't tell anybody. Like her lawyers, her investigators, her mitigation specialist. Like, why would you not, if you're 100% innocent, tell the people defending you in your death penalty trial what really happened? Why would you wait till 11 years after the trial and tell it to some producer for Peacock? But that's what happened. With that said, what she said in this docuseries is that her attorney, Jose Baez, got it wrong. I'll never forget his opening statement. I mean, it changed that trial, turned it on its head. It was powerful, it was effective, but it was very specific about what happened the day that Caylee died. She drowned in the pool. George retrieved her, screaming at Caylee Anthony, "Look at what you did! Your mother will never forgive you." That's not what she says in the docuseries. That's not what she said. Her story contradicts that. It's unbelievable. Like, that's what Jose Baez told the jury. And why did he tell the jury? Did he just make it up out of thin air? Or did someone tell him, like maybe his client? What is going on? Like I said, bizarre, absolutely bizarre. So, what happens in this docuseries after she does all this and tells her story? It turns into the prosecution of George Anthony. By the time you get to the third episode, it's just allegation. He's a pedophile. He molested Caylee. He killed Caylee. He's the murderer. That's the big conclusion here. But she never told anybody before the docuseries. As a matter of fact, we get to see the moment where it's all revealed with her investigator who, has taken her under his wing and has helped her in her post not guilty life. But like for the first, you don't tell him why you're facing the death penalty, what happened here? And by the way, I'm a former prosecutor, as you know. If you presented the so-called evidence that George Anthony was a killer to a grand jury, you wouldn't even get an indictment. It'd be laughable. The only evidence you would have would be the words of Caylee Anthony. Imagine hanging your hat on that. That's all it is. That's all it is. It's unreal. So as I'm watching this, I'm wondering, how many more lies did I just experience in this all-night binge? How many more lies? Now, I'm not trained in this, right? I have to base it on other things, but I kind of have a way where I can decipher when Caylee Anthony is lying. And I've deduced that it's usually when her lips are moving. You see her lips moving, she's very likely lying about something. It was unreal. I'm not trained in all this, but tonight I've got the experts who can talk all about body language, what you actually see and hear when someone is speaking, what they're really saying. Let me introduce them. In Orlando, Florida, of course in Orlando, Florida, jury consultant, human behavior expert, Susan Constantine, who was with me years ago down there when all of this was happening. Great to see you. In Loveland, Colorado, statement analysis expert, Lieutenant Robert Schaefer. Great to see you. And in Bradenton, Florida, voice stress analysis expert, Jerry Crotty. Great to have everyone here. So what we're going to do together is take a look at a little piece of what I experienced last night, and then have everyone give us a little bit of analysis of what you're seeing, what you're hearing. And I know you all watched the entire thing like I did, so you can take your comments beyond that. But let's start with this. In this three-part series, Caylee Anthony says she went to sleep with her daughter next to her, then being awoken by her father asking her where Caylee was. Caylee says she searched the house and the yard before seeing her father holding Caylee in his arms.
I can see him standing there with her in his arms and hand her to me and telling me that it's my fault, that I did that, that I caused that. And I just collapsed with her in my arms. She was heavy, she was cold. As I'm sitting there with her on my lap, just hysterical. Just staring at her, not knowing what to do. He takes her from me and he immediately softens his tone and tells me it's gonna be okay. That she was going to be okay. That's what he said to me. And I don't know how long I sat outside. I don't know where he went. He took her from me and he walked away.
And she continues to talk about, for folks who haven't seen it yet, that she believed Caylee was alive. And during those 31 days that we've always talked about, her and her dad were meeting up and he was telling her what to do, what to say, how to act, all of that. Unreal. All right, let's get some analysis and reaction. Susan Constantine, go ahead.
Yeah, so the first thing I noticed is, and this has been very consistent throughout all three of those documentaries, is that there's this enormous amount of anger, scorn, contempt. Disgust was the big one. You know, when you see the nose scrunching up like this, that triad of emotion is often linked with deception. So when we see this, when she's talking about our daughter, she's got this disgust. I want to share something with you. When you and I were in that courtroom that day, right? We listened to the entire trial. But when she was talking about when the human decomposition, when they opened up the trunk and that there was this odor of human decomposition, right then, Caylee Anthony showed disgust. So she's doing the same thing here again. So when she reenacted that moment, when she could actually remember what that odor smelled like, she saw the disgust. This disgust is more about her anger, her hostility that is vented towards her father. That's where that is coming from. And she's doing that because that's what fuels her annoyance. So it's a form of status, and she's trying to position herself. So the more she tries to position her status and try to appear truthful, she then ups her game, and that anger, disgust, and contempt, and that triad is always considered deceptive.
There was a ton of anger that I was feeling. Lieutenant Robert Schaefer, your thoughts?
Well, as I look at that, oh, by the way, it's good to see you. Hey, as I look at that clip, one thing really stands out to me. What I do is look at language, the story somebody has to tell, and the way they put that story together to tell me whether that's a truthful thought process or deceptive. And that portion of her story is told with a focus on emotion. It's she doesn't give a factual account. And there's facts involved, but her goal there is to convey emotion, which is kind of related to what Susan was saying. And when a person recalls from memory, and that would be a truthful statement, that's not necessarily what they do. They want people to understand what happened. She's more concerned about conveying emotion, how she felt, how she was made to feel, rather than the facts of what actually happened. So that would be symptomatic of a suspicion of deception.
Jerry Crotty, your thoughts?
Well, I get to analyze what she says through a computer program. And what I'm looking for is that conflict in the brain. When people are being truthful, there is no real conflict. It just comes out very smoothly, and it's spontaneous and everything else. And so when I analyze a lot of her statements, as you will see, that you will see this conflict on her through most of her testimony that she gave during her documentary. And you know, it's just fascinating to watch, just like you said.
What do you mean by conflict? Explain that just a little bit.
Okay, so you have two sides of the brain. You got, and I'll just kind of like make it easy. You have two sides of the brain. You got one side of the brain that's, let's just call it pure. It basically runs your heart, it runs your lungs, it does everything it's supposed to do, and it does it all automatically. Then you got the other side of the brain that's a little bit devious, and that's the side where deception comes from. And when a person decides to lie, there is this reaction in the brain. One side says do it, the other side says we're not doing this today. But unfortunately, you can push it through. And what ends up happening is that stress, that reaction, that conflict that occurs in the brain, it goes out throughout the body. And that's what everybody's looking at here. I get to see it through the voice, and Susan gets to see it in the body, and Bob gets to see it through their language, what they're saying. And so it's really important the way that we do these things. And it's just, this is very fascinating to me, what she said.
Now, Susan, one thing that I noticed just looking at, you know, there was a lot of stuff going on in her face. And I noticed a lot of times she would finish saying something and kind of do a little thing with a lip, I would see that a lot. It would be like at the end of a thought or something, and then it would stop, and then the camera would stay on her for a second, and it started jumping out at me. The other thing is this furrowed little brow in the middle here. Like sometimes it was like deeper than the Grand Canyon in there. What do those things mean? What do they mean, if anything? You see it sort of in the first two here, but I saw it even deeper.
Yeah, so anytime you see an asymmetrical movement, especially with the mouth, that's associated with contempt. But what she does is it's more like almost uncertainty. You know, it's almost where she bites the side of her mouth. It happens right after a statement. So when she says something and then she can hold it for a certain amount of time, then the duping delight pops out. You see the side movement, that the asymmetrical movement, which is doubting the words that she said. So she doesn't believe it, but she's trying to pull it off. Right? So that cognitive load, it's building up, and then it releases right at the very end. And that's also what you see in the furrowed eyebrows. Furrowed eyebrows are when somebody's under a lot of tension, right? They're angry and they're tension, and their eyebrows are coming down, right? So when you're upset about something, you're sad, which is what I would expect to see, her eyebrows would turn up, but it furrows in. So she's constantly in this state of anger and contempt, this triad of emotions, which is fueled by her inner hostility. So that side contempt is partly is a more of a complex emotion. So it's contempt, moral superiority, but it's also self-doubt, and she's trying to convince rather than convey, and it actually comes out in droopy delight on the side of her face.
Lieutenant Robert Schaefer, I want you to take a listen. This is Jose Baez, that opening statement that I referenced. Here's a piece of it. Because to me it was significant, because this was the game changer in the trial. It was powerful. It turned everything on its head. Let's listen to it one more time.
How in the world can a mother wait 30 days before ever reporting her child missing? It's insane. It's bizarre. Something's just not right about that. Well, the answer is actually relatively simple. She never was missing. Caylee Anthony died on June 16, 2008, when she drowned in her family's swimming pool. You're gonna hear that Caylee loved to swim, and Caylee could get out of the house very easily, and it escalated.
A couple things pretty amazing in that clip, because in the docuseries, she says she had no idea what he was gonna say, and she didn't know that he was going to get into everything that he did. But Lieutenant, let me ask you, here, Jose Baez, very specific in what happened. That story has changed. I know as a lawyer, you cannot just say whatever you want in your opening statement. It has to be based upon something. The only person who could tell him what happened would be Caylee Anthony. How do you account for the statement seemingly changing from what her attorney said to what she said?
Well, I think that in my impression, based on the way he states things, that he probably wasn't sure right up to the last minute, or at least right the final hour, exactly what the defense was going to be. And so what I understand about some other things that I've seen, that she was not clear with him exactly what that was going to be, and that was kind of a final decision that they just had to run with. I think they felt that they could build a good enough case with that, with the information that they had. But he absolutely depends on her to decide what that defense is going to be. And I noticed that one thing about that is that he stated that he described her in the third person. He says, what would cause a mother to do this? And although as though she's not really a person, it wasn't specific to her. So what would cause a mother to wait 30 days? So he wasn't specific to Casey. And so there's, that's what we call lack of commitment.
That's fascinating.
Talking about somebody in the third person is a lack of commitment.
Absolutely.
That shows that he doesn't even really believe, you want to put it that way, what she had to say.
Unbelievable. All right, Susan, Constantine, Lieutenant Robert Schaefer, Jerry Crotty staying with us. We've got more analysis, especially when we get to the accusations against George Anthony. That is next.
Casey has a brother, and he too wanted to follow in his father's footsteps. And on certain occasions when he was a teenager, he attempted to also touch his sister. And some of this behavior, you'll realize that the apple doesn't fall very far from the tree. We are what we are because of who brought us into this world and how we were raised. Casey was raised to lie.
Caylee Anthony's attorney, Jose Baez, told the jury his client was molested by her father and her brother as a child. And now, 11 years after she was found not guilty of murdering her daughter, Casey addressed the same accusations in the Peacock docuseries Caylee Anthony, Where the Truth Lies.
When I was 8 years old, my father started to come into my room at night. I was physically hurt, scared because I was physically hurt, and I can't tell mommy what happened. She'll get mad at me. That's what I was told. With my father, the abuse one day just stopped, just before my 12th birthday. My brother started coming in shortly after I turned 12. And it stopped around the time I turned 15. Wasn't the same thing that happened with my father. My brother never raped me, no. No, absolutely not. But it was close enough. Close enough where there was a pattern.
But you did tell your mom about Lee.
I did not.
Now, she also makes one more accusation of rape in the docuseries, and that is by Caylee's father. The story is she went to a party, someone slipped her something, knocked out, no memory at all. I don't even think she knows who the father was, according to what she said in the docuseries. So she's raped by her father, molested by her brother, and then raped by the father of Caylee Marie, who is someone who, to this day, we still don't know who it is. Okay, let me bring back in my experts. Susan Constantine, human behavior expert, jury consultant. Lieutenant Robert Schaefer, statement analysis expert. Jerry Crotty, voice stress analyst expert. We just heard her there accuse her brother and her father. Jerry, I'll start with you. Do you hear that same conflict during this part of her statements?
Yes, I was able to run this through the computer to see what came up and to kind of give you an idea what these things look like. If there's no stress associated with the word, looks like this Christmas tree over my shoulder here. It's just a pointy top, looks just like a Christmas tree. If it looks anything other than a Christmas tree, that's when we start to kind of pay attention to it. This statement that she made was not very many Christmas trees. There was a lot of stress associated with it. And I want to say that this is a different type of stress. This isn't from, you know, recalling incidents or anything like that. I have examined multiple individuals, probably close to 1,000 individuals. And if they have nothing to worry about what they're saying, that information should flow freely from the individual, and there should be no stress created from it. And so, yes, I did see some rather interesting output on that one.
Susan, your thoughts about what we just saw?
Well, one of the things that stood out to me was there was no eye movement. You know, when we think about Clinton, when he was accusing Monica Lewinsky, her eyes never moved. You would expect for her to, when she's recalling something, your eyes are going to shift. It's going to go back into memory and replay the tape. And Jerry really talks to that really well in our training class. But that was one of the major things that I saw. Again, anger. So you would have expected her to feel shameful, embarrassed, but her eyes were very fixated. There was no rapid eye blinking, which you should have seen because that was a very stressful situation. That would have been more consistent than the staring eyes.
All right, we're out of time for tonight, but I just want to go around the horn one time really quickly. At the end of the day, after watching everything and analyzing it, 0 to 10, 10 being the truth, the whole truth, nothing but the truth, 0 being nothing but lies, what's your number? Susan?
80% of it is lies, 20% truth.
Lieutenant Robert Schaefer?
Yeah, I would have said 70-30.
70-30. Jerry?
I'm going to give you one better than that. I was waiting for her pants to burst into flames. So that's very much
pants
very much it.
On fire. There could potentially be a lawsuit against her. Hear me out. Now, Caylee Anthony's attorney, Jose Baez, told the jury that his client, we know who she is, was molested by her father and her brother as a child. And now, 11 years after she was acquitted of murdering her daughter, Caylee addressed the same accusations in the Peacock docuseries, Caylee Anthony, Where the Truth Lies.
When I was 8 years old, my father started to come into my room at night. I was physically hurt, scared because I was physically hurt, and I can't tell mommy what happened. She'll get mad at me. That's what I was told. With my father, the abuse one day just stopped, just before my 12th birthday. My brother started coming in shortly after I turned 12. And it stopped around the time I turned 15. It wasn't the same thing that happened with my father. My brother never raped me, no. No, absolutely not. But it was close enough. Close enough where there was a pattern.
But you did tell your mom about Lee.
I did not.
Don't be influenced by the music, please. Now, later on in the docuseries, Caylee Anthony refers to a comment her father made at Caylee's funeral and goes on to suggest that her father is a pedophile.
Caylee Marie Anthony, who not only meant the world to me, but meant the world to my family, and so many of you that never got a chance to actually hug her, smell her hair, smell the sweet sweat when she came in from outside.
Are you kidding?
To hear her call me JoJo, I missed that kiss on the cheek, that special hug that I tell everyone it's so great to get a hug from someone, but to get a hug from a small child, that gives me energy like you couldn't imagine.
That's not normal. Nothing about that is normal. You're outright telling the world that you're a pedophile.
Now, in other parts of the docu-series, if you watch it, I binged it, I told you I did it last week, there's sort of this overall theme throughout, and really coming through the words of Caylee Anthony herself, that what really happened to her daughter was Caylee fell asleep, and then her father shows up with little Caylee and says, don't worry, everything will be all right, and then disappears with her, and then she's found dead in the woods. And then her and her investigator talk about, he must have smothered her. Very possible. And he smothered her after he's trying to molest her as well, because as she's accusing him, he's a pedophile. So with that in mind, a lot of people are like, this is outrageous. You got to do something about it. Can't you do something about this, George? So if it's not true, and I'm starting with this premise, that those allegations are not true, that George Anthony didn't molest and murder his granddaughter, George Anthony didn't molest and rape his daughter, if those things are not true, could George Anthony sue his daughter, Caylee Anthony, for defamation? So we were talking about this, and I'm like, well, there's only one way to find out. Do we know anyone who knows anything about defamation cases? Is there someone out there, and we're like, where? We need somebody, we need a heavy hitter. We need like someone who could win a big case like that. You know who I'm talking about. Joining me tonight, Washington, D.C., trial attorney, partner with Brown Rudnick, LLP, and the lead attorney who represented Johnny Depp during his successful defamation case, Ben Chu, back with us. Ben, great to see you.
Great to see you, Vinny. Thank you for having me on again.
All right, so I want to walk through this whole process with you because, and I'm serious about this potential, because a lot of people are talking about a potential suit here. If someone like George Anthony was going to bring a lawsuit like this, he'd have to go see an attorney like you. How does an attorney who represents people claiming defamation, how do you sort of vet the case? Like, what makes you take the case versus not take a case like this? What would a defamation attorney, what would the meeting be like with the client? What would you discuss, and what would be some of the factors that you would take into account here?
Well, Vinny, as you know, and you're assuming truth, but truth is always a defense in any defamation case. So due diligence on that point, i.e. whether the allegations are true, has to be done, and has to be done extensively, more so than in a general commercial case, because the attorney has to be as sure as he or she can be that the allegations are false before he would take the case or advise the client to proceed. And then you go on to other factors we can discuss.
Go ahead. What are some of the other factors you're going to take a look at there?
Well, the other factors you would discuss are whether these are allegations of fact or allegations of opinion, which aren't, as you know, allegations of opinion are not actionable. In this case, I think you clear that hurdle, because the accusation of being a pederast, it's a pretty clear allegation. It's an allegation of a crime, and it's a crime so heinous in our society, or really any society, that it is considered defamation per se. So the damages to the plaintiff, again, under your hypothesis, assuming the falsity of the allegations, this is a particularly heightened form of defamation per se. But there's another factor I think you're going to get at, and I shouldn't anticipate your questions because I'm not that smart. But another factor you always consider, and it was relevant in the Depp case as well, is you consider whether the potential defendant, as a practical matter, would have the means to satisfy any judgment.
So let me ask you this. Before we get to the money aspect of it, do you ever look at the person making the statement? So say, hypothetically, the person is a convicted liar, right? Someone who's an admitted liar, someone who made an entire documentary talking about how she lied, someone who was convicted in court of lying. Does that come into play as well in evaluating the strength of your case if you're accusing a convicted liar of defamation?
Absolutely, Vinny, and I should have said that you consider the credibility and the record of both the plaintiff and the defendant. And in this case, as you point out, though she was acquitted of the murder back in 2011, she was convicted of 4 counts of giving false information to law enforcement. And as a matter, although some statements were made by her counsel, it's very clear that she changed her story about how Caylee, came to be murdered. It's outrageous.
Changed it a bunch of times. So explain to folks how this would go down. We all watched Johnny Depp v. Amber Heard, so if it's George Anthony versus Casey Anthony, we'll talk about Peacock in a moment, but if it's George Anthony versus Casey Anthony facing off, she'd have to testify. And if she's accusing him of being responsible for the death of her daughter, can you put her on the stand and question her about her role potentially in the death of her daughter?
Absolutely. Absolutely. You would put her on in deposition, of course, before you put her on at trial, and you would walk her through every false statement that she's made, every contradictory statement. She could always take the fifth.
Wait, let me ask you about that. Can she take the fifth if she's been criminally acquitted of the murder?
That's as always, you ask the best question. And if she faces if any further charge would constitute double jeopardy, then George's lawyer could say there's that she's not entitled to take the fifth, and that would be resolved by the judge. But I think George's lawyer would have a very strong argument that the fifth would not be available to her, unless. I suppose she could make a creative argument about potential perjury convictions, new perjury convictions. But in any event, however she tries to get unwound from that particular axle, I think you would have all of that in the form of testimony. And I think she would just be in a very, very difficult place were she to be a defendant in a defamation case.
And my belief, that case would be perhaps even more revealing than the criminal trial was.
Yes, it would, because their discovery in the civil context, as you know, is a very broad standard. Anything reasonably calculated to lead to the discovery of admissible evidence. And because these particular defamatory statements go right to the heart of what happened to Caylee and what allegedly happened to Casey, all of this would be fair game. This would be a disaster for Caylee Anthony. And, opening up this can of worms by doing this docuseries really would not have been something any attorney would have advised.
Yeah, and the one question that has been answered there, I haven't heard it anywhere, is whether or not she got paid. I'm presuming there was some payment either for her interviews, her participation, or some pictures or whatever that she may have provided, but I don't know. She may not have been paid for the whole thing. All right, so let's get back to that other statement where you were talking about money, which is, if an attorney's going to take a case, there's got to be, some way to satisfy a potential judgment. I don't know if she has 2 nickels to rub together. She may have a few dollars here and there, but nothing substantial. But this was a docuseries that was produced by someone. It was placed onto a streaming service. If, and again, this is the big if these statements are not true, would they be potential defendants in the case as well? Would it be, who could be on the hook?
Yes, that's where you would probably go. And again, assuming that she is judgment proof, which is an assumption, but not an unreasonable one, unless she was paid a lot for this docuseries, then I think you would have to look for a deep pocket. And the deep pocket could be the producers of the docuseries, who could be brought in as defendants. Publications, producers of these things are brought in all the time. Standards are somewhat different, but yes, I think if you were to proceed on behalf of George, I think you would have to advise George that you would want to be looking potentially at the producers of the docuseries as potential defendants.
Yeah, and this is a pipe dream of mine, but I don't think it'll happen, that if the case is brought, that it's just George versus Casey, and he's doing it not so much for the money, but to clear his name. And that would take an incredible sacrifice by attorneys to do that for free, pretty much, because I don't think, again, she doesn't have any money. But incredible insight on this Friday night.
My daughter's been missing for the last 31 days. And you know who has her? I know who has her. I've tried to contact her. I actually received a phone call today, now from a number that is no longer in service. I did get to speak to my daughter for about a minute. And you last saw her a month ago? 31 days. It's been 31 days.
Okay, that was 2008. Caylee Anthony on the phone with police. Now, she didn't call them. Her mother called them, then handed her the phone. But it took 31 days for authorities to be contacted when her child was missing. Okay, when her child was missing. Yet, flash forward 13 years, right? Someone spills water on her leg. She calls police in 5 minutes. New phone call. She's at a bar in West Palm Beach, Caylee Anthony. Apparently, she's got some feud going with this other woman about some guy, and they get into some sort of an argument. She said she was verbally assaulted, and then she called police. Take a listen.
911, what is the address of your emergency? 9 emergency. Can you have West Palm come over for an incident report? Okay, what is the address? It's O'Shea's. It's right next to the department. It's in the 500 block. Okay, 531 Clematis Street. What's the incident?
It's an assault. It's a thrown drink. No, but no, I'm fine. Thank you.
Are they still
no,
there?
It was a repeated incident. No, I'm still here. Yes, it was a repeated incident. It was harassment on top of the repeated drink. The thrown drink.
And they threw a drink at you?
Yes. Thank you. I'm fine. No, it was a repeated incident. It was a verbal assault outside and then a thrown drink inside.
Okay, and where is
I would
the
just like to
subject
make an
that threw the
official
drink?
report. Yeah, no, I would just like to make an official report.
Okay, where is the person that threw the drink?
She's already left the premises.
Okay.
But I have
And
her
your name?
information, her date of birth, her phone number.
Okay.
Just so if it happens again, so I can file a restraining order. It has happened repeatedly.
Okay, what is your name, please?
And a good date of birth.
And your phone number? All right, I have to call in for service. We're going to get someone out there as soon as possible, okay?
Thank you so much. I appreciate it.
No problem. Bye-bye.
All right, when they send out the 911 calls, they mute the names, right? But could you imagine being the 911 operator and says, and what's your name? Caylee Anthony. She's like, what? All right, let's bring in our special guest. We got to get to the bottom of this one. Joining us from West Palm Beach, Florida, the state attorney for Palm Beach County, Florida, Dave Arenberg. Dave, this is, I know you're busy, but we appreciate you coming on tonight. Big investigation going on down there. You know, was there just one drink thrower? Were there two? How deep is your investigation tonight?
Good evening, Vinny. It's good to see you on a Tuesday rather than our usual Wednesday night. The investigation has not reached our office. This is just a police matter where they approached Caylee Anthony on the scene and they filled out an incident report, but it has not been submitted to our office. So apparently they have not found that there was probable cause of a crime has been committed, but also it seems that Miss Anthony did not want to take it any further. This apparently is a feud that's going on with this other individual who, according to reports, is involved with the same man or ex-boyfriend. There's a guy involved, and this has happened more than once, but it has never reached our office.
Okay, I've got the report right here. Let me just read part of it for you, Dave, and for the folks at home, obviously. And this is the officer notes. It says, I made contact with Caylee Anthony, and he gives the date of birth and everything, who advised she was in a verbal argument with Thelma Moya about an ex-boyfriend. They were dating at the same time. Seems like she should be mad at the guy, not the girl. Anyway, Anthony stated the argument got heated and Moya spilled water on her left leg. Anthony wanted the incident documented. I informed her about how to file a restraining order. However, Anthony advised she did not wish to do that at this time, although it's been an ongoing issue for years. And then the female advised that she keeps getting drinks thrown in her face. Okay, let's start with spilling water on the leg, Dave. Is that a violation of any of Florida statutes?
Yeah, it could be. It could be. And it's interesting. She says the water on her leg and then said it's been happening on her face. Either way, if someone throws a drink in your face, yeah, that could be an assault and battery. A battery is an unwanted touching. It's just a misdemeanor, and it's a very low bar. So you could file charges, but she apparently didn't want to go that far. And then if you want a restraining order, that's not even our office. That's something that's handled on your own with the court system, and you can get that restraining order. But she didn't even want to do that here. And I do find it interesting, Vinny, as you said, that she was very quick to call the police when this happened, when she never called the police when her daughter was missing.
Yeah, I think that's the part that a lot of people, it's going to rub a lot of people the wrong way. Now, obviously, she was found not guilty of the murder. She's found guilty of some check fraud stuff and lying to police, and some stuff's been overturned, et cetera, et cetera, et cetera. But everyone's entitled to be able to go out and not have drinks thrown in their face, obviously. So what would you suggest to someone who's in her position at this point? When do you go to try to get a restraining order? What's the level of fear that people need to be in, or what's the level of conduct that would even get to that point from your perspective?
Well, it's up to the individual to determine whether they're in fear of someone else. And if they are, then go to a court and get a restraining order. And you have to show a certain amount of evidence. You just can't just say, hey, I just am in fear. You have to show that it was an incident that happened. And And there's a certain standard, but our office is not even involved because it's not a criminal matter until someone violates the restraining order. Now, once someone violates a restraining order, then it becomes a crime, and then we get involved. But until then, we never see it. We don't participate in it. And it's up to the individual to go get it. You have to, and the restraining order keeps that person away from you. And if this continues to happen, as she says it has happened, then yeah, the police gave her the good advice. Hey, you may want to get a restraining order, but she didn't even want to get that. So this seems like some self-inflicted drama that she doesn't want to get the restraining order. She didn't want police to go any further. She just wanted a record of it. And also, you know, the police are not quick to start filing charges when someone starts, you know, pouring water on your leg. Now, maybe if it went right in her face, that'd be a different story. But this seems to be it's like real small potatoes incident. And the only reason why it's news is because the individual is Caylee Anthony.
Oh, absolutely. Of course. That's why everyone wonders, you know, what's life like? Because at one point she was the most hated woman in America. We haven't taken the poll recently. She may still be in the top 10. I don't know. Haven't run the numbers recently. Are you surprised, though, that someone who has lived relatively under the radar for some time now would you know, because she knows if she makes that call and she's given their name, someone's going to hear it, someone's going to find out, and people like me are going to talk about it.
Vinny, she has not lived under the radar locally. A lot of people in town have seen
Really?
her. I even ran into her. I was shocked. I was at a funeral for a criminal defense lawyer who died way too young, and outside, she introduced herself to me, and I was shocked. So she's not under the radar at all.
Wait, time out. How does she introduce herself?
Well, after the funeral, we were in, you know, people were talking in groups, and there was a woman in the group I was talking to that looked familiar, and she saw me and seemed like she recognized me, and I was like, I looked at her and she said, Dave Ehrenberg, and I said, yes. He said, Caylee Anthony. And I'm usually not speechless very often, but I was speechless then. And she's not keeping a low profile. She was videoed at a rally of the women's rally, I think like after Trump was elected back in 2017, I think after he took office. She was at a rally here locally holding up a sign. And so she is not keeping a low profile here. A lot of people have seen her. I'm not surprised she called the police. And this seems to be very typical for a course of conduct. She's hiding in plain sight.
Let the record reflect that the defendant is present along with counsel for the defendant. Both sides ready to proceed. It's been brought to my attention that the jury has reached a verdict. State?
The state's ready to proceed, Your Honor.
Defense?
Defense is ready.
To those in the gallery, please do not express any signs of approval or disapproval upon the reading of the verdict. Let's return to jury. State recognized presence of the jury.
We do, Your Honor.
And does the defense.
Yes, sir, we do.
Good afternoon, ladies and gentlemen of the jury. Have you reached a verdict? Yes, sir. Would you hand the verdict form to the court deputy, please? Will the defendant rise along with counsel? Madam Clerk, you may publish the verdicts.
Thank you, Judge. In the Circuit Court for the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus Caylee Marie Anthony. As to case number 2008 CF 15606-0. As to the charge of first-degree murder, verdict as to count 1, we, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, on this 5th day of July, 2011, signed foreperson. As to the charge of aggravated child abuse, verdict as to count 2, we, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of aggravated manslaughter of a child, verdict as to count 3, we, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 4. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 5. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 6. We, the jury, find the defendant We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict is to count 7. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson.
Madam Clerk, you may poll the jury.
Juror number 1, were these your true and correct verdicts? Pardon? Juror number 1, were these your true and correct verdicts? Not guilty. Were they all your true and correct verdicts?
Yes.
Juror number 2, were these your true and correct verdicts?
Yes.
Juror number 3, were these your true and correct verdicts?
Yes.
Juror number 4, were these your true and correct verdicts?
Yes.
Juror number 5, were these your true and correct verdicts?
Yes.
Juror number 6, were these your true and correct verdicts?
Yes.
Juror number 7, were these your true and correct verdicts?
Yes.
Juror number 8, were these your true and correct verdicts?
Yes.
Juror number 9, were these your true and correct verdicts?
Yes.
Juror number 10, were these your true and correct verdicts?
Yes.
Juror number 11, were these your true and correct verdicts?
Yes.
And juror number 12, were these your true and correct verdicts?
Yes.
Thank you.
Okay. Will counsel and the defendant approach the podium? Not all the counsel, but just representative sample. Caylee Marie Anthony, a jury of your peers, having found you not guilty as to the charge contained in count 1 of the indictment, murder in the first degree, at this time, I will adjudge you to be not guilty. As to count 2, the crime of aggravated child abuse, a jury of your peers having found you to be not guilty, the court will adjudge you to be not guilty of the crime contained in count 2. As to count 3, aggravated manslaughter of a child, a jury of your peers having you found you not guilty, I will adjudge you to be not guilty of that count. As to counts 4, 5, 6, and 7, providing false information to a law enforcement officer, I will adjudge you to be guilty of those counts in order that you be fingerprinted here in open court at this time. It has to be an open court. Okay, Mr. Baez, Mr. Mason, will you be prepared to go to sentencing Thursday or Friday of this week? Okay, then we'll set sentencing Thursday at 9 a.m. in this courtroom. Okay, are there any other matters that we need to take up at this time?
Nothing from the state, Your Honor.
Ladies and gentlemen of the jury, On behalf of the citizens of the Ninth Judicial Circuit, I would like to express my sincere thanks and appreciation for your service as jurors. You are all residents of Pinellas County, Florida. And we came over there, met with you, questioned you, and took you away from your families for a very extended period of time. And for that, I say thank you. As I told you when I first spoke with you, in talking about jury service, that one of the most important obligations of citizenship, in my opinion, was service on a jury. I tell you it was very important that if we believed in that constitutional provision that provides a right to trial by jury, that it was important for people to serve no matter what that sacrifice would be. As you can tell by some of the questions that some folks answered, a lot of people did not want to serve. You knew it would be a hardship, and you were candid with the attorneys. You answered all their questions, and you served. And for that, we thank you. I would also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and vote shall remain their private affairs as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your jury work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious or from those who might seek to find fault with you. From the media, from attorneys, or elsewhere, it will be up to you to decide whether to preserve your privacy as jurors. Again, thank you. You're hereby discharged, and I will see you shortly back in the jury room. Thank you. Okay, ladies and gentlemen of the jury, there are a number of stipulations that I'm going to read. Mr. George, you want me to read them all at one time, or you want those read before you introduce the videos?
Your Honor, it might be a little cleaner or clearer if we were to do them one at a time.
Okay. Then you may proceed, Mr. George.
Your Honor, as it relates to what's been previously marked for identification, LN, which is a video of Target from June 30th of 2008, I believe that the state and the defense have entered into a stipulation. Would you care to read those, or do you want me to read those?
It would be admitted in evidence noting previously raised objections. And the stipulation is as follows. The copy of the video surveillance recorded at Target at 718 McGuire Boulevard, Orlando, Florida on June 30th, 2008 is a true and accurate representation of the business records of Target. The parties have agreed to this fact, and it should be considered as true in your deliberations. It will be received in evidence as what, Madam Clerk? All right.
Your Honor, may I publish that at this time?
You may publish.
Your Honor, apparently we're having multitude of technical issues. What I would suggest at this point is just to go through all the stipulations and have them entered, and hopefully at a later time we can publish them.
Issues, because the second one may work. You want to try that?
All right, the next one, Mr. George.
Thank you, Judge. The next one has previously been marked for Exhibit LO, States LO, which is a video from J.C. Penney, also on June 30th of June 30th, 2008.
Noted in previous objections, they will be admitted. It will be admitted as states numbered. This is the following stipulation, members of the jury. The copy of the video surveillance recorded at J.C. Penney's on June 30th, 2008 is a true and accurate representation of the business records of J.C. Penney's. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Your Honor, I've been told that this particular video will work, so I would ask that we go ahead and publish this one.
You may publish.
Thank you. Your Honor, at this time, the state would move what's been previously marked for identification LP, which is a J.C. Penney video from July 1st of 2008, into evidence.
Noted in previous objections, it would be admitted into evidence as state's exhibit. Ladies and gentlemen of the jury, the following stipulation. The copy of the video surveillance recorded at J.C. Penney's on July 1st, 2008 is a true and accurate representation of the business records of J.C. Penney's. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, Judge. At this time, the state would ask to publish this particular video.
You may publish.
Thank you, sir. Your Honor, the state would move what has been previously marked for identification LQ, which is a video from IKEA on July 5th of 2008. As the state's next in line.
Noted in previous objections, it will be received in evidence as state's exhibit numbered. Ladies and gentlemen of the jury, the following stipulation. The copy of the video surveillance recorded at IKEA on July 5th, 2008 is a true and accurate representation of the business records of IKEA. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, sir. May I publish?
You may publish.
Thank you, sir. Or not. Your Honor, at this time, the state would move what has been previously marked for identification LR, which is a target video from July 7th of 2008.
Noted in previous objections, it will be received in evidence as states numbered. Ladies and gentlemen of the jury, this is the following stipulation. The copy of the video surveillance recorded at target 3770 North Goldenrod Road, Winter Park, Florida, on July 7, 2008, is a true and accurate representation of the business records of Target. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, sir. May I publish?
You may publish.
Thank you, sir. Your Honor, at this time, the state would move what has previously been marked for identification LS. It's a video from Target on July 8th of 2008, as states next in line.
Noting previous objections, it will be entered in evidence as states numbered. Ladies and gentlemen of the jury, the following stipulation. The copy of the video surveillance recorded at Target, 325 North Alafaya Trail, Orlando, Florida, on July 8, 2008, is a true and accurate representation of the business records of Target. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, Your Honor. May I publish?
You may publish.
Thank you. Your Honor, at this time, the state would move what has previously been marked for identification LT, which is a target video from July 10th of 2008 into evidence as the state's next in line.
Noted in previous objections, it will be received in evidence as states numbered. Ladies and gentlemen, the following stipulation. The copy of the video surveillance recorded at Target 325 North Ophelia Trail, Orlando, Florida, on July 10th, 2008, is a true and accurate representation of the business records of Targets. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, sir. May I publish?
You may publish.
Thank you, sir.
Objections, Judge?
I said,
I'm sorry. I may have not heard it.
so the record will be clear, is noted in previous objections. Thank you, sir. You may publish.
Thank you, sir. Your Honor, at this time, the state would move what has previously been marked for identification LU, which is a target video from July 10th of 2008, into evidence as the state's next in line.
Noting previous objections, it would be entered in evidence as states numbered. Ladies and gentlemen, the following stipulation. The copy of the video surveillance recorded at Target 3770 North Goldenrod Road, Winter Park, Florida, on July 10th, 2008 is a true and accurate representation of the business records of Target. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, Your Honor. May it be published?
You may publish.
Thank you, sir. Your Honor, at this time, the state would move what has been previously marked for identification LV, which is a video from Winn-Dixie on July 12th of 2008 into evidence as the state's next in line.
Note in previous objections, it would be admitted in evidence. It states numbered. Ladies and gentlemen, the following stipulation. The copy of the video surveillance recorded at Winn-Dixie on July 12th and July 15th, 2008 is a true and accurate representation of the business records of Winn-Dixie. The parties have agreed to this fact, and it should be considered as true in your deliberations.
May I publish, Your Honor?
You may publish.
Thank you. And Your Honor, we'd like to publish the next Winn-Dixie 7/15/2000.
You may publish.
Thank you, sir. Your Honor, apparently we're having some technical issues with that one. May I ask that if we can get those technical issues resolved, we can publish it at a later time?
Yes, sir.
Thank you. Your Honor, at this time, the state would move what has been previously marked for identification LW, which is a Bank of America video from July 15th of 2008.
Noting previous objections, it would be admitted into evidence. It states exhibit numbered. Ladies and gentlemen of the jury, the following stipulation. The copy of the video surveillance recorded at Bank of America on July 15, 2008 is a true and accurate representation of the business records of Bank of America. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Provided the technology cooperates, Your Honor, may I publish?
You may.
Thank you. Again, Your Honor, we'd like to publish that at a
You may
later
publish.
time.
At a later time?
Thank you, sir.
Okay.
Your Honor, at this time, the state would move what has been previously been marked for identification LX. It's a Blockbuster video from July 15th of 2008 into evidence as the state's next in line.
Noting previous objections, it would be admitted into evidence. It states exhibit numbered. Ladies and gentlemen of the jury, we have the following stipulation. The copy of the video surveillance taken from the video recorded at Blockbuster Video on July 15, 2008 is a true and accurate representation of the business records from Blockbuster Video. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, Your Honor. And again, we would ask, once we have the technical issues worked out, if we may publish this at a later time.
You may.
Thank you, sir.
Cynthia Anthony, Cynthia Anthony.
You may proceed.
I please the court, Ms. Drain. Good morning, ladies and gentlemen. Good morning, Mrs. Anthony.
Good morning.
Mrs. Anthony, do you recall several years back when there was an incident involving your son Lee going into Casey's room at night?
Objection, Your Honor.
Overrule at this point. Yes, no.
No.
Were you ever made aware that there were incidents of your son going into Casey's room at night?
Objection, hearsay. Call for hearsay response.
Sustained.
did you ever have to deal with an issue?
Objection, may we approach?
You may approach. Objection sustained. Next question.
Mrs. Anthony, I just have a couple more questions for you. Do you recall testifying 6 months ago that you believed Caylee was still alive?
Yes.
Okay. Were you testifying truthfully at that time?
Yes, there was still a part of me that believed that Caylee was alive at that time.
And in January of 2009, you held a memorial service for Caylee Anthony.
No, it was February of 2009.
And you had requested that Caylee's remains be cremated.
Yes.
And approximately 1 year, actually 2 years later, you still held the belief that...
Let him finish the question. Don't answer the question, Ms. Anthony.
You still held the belief that Caylee was alive despite all of that.
Is there objection to the question?
Relevance.
Relevancy?
I think it's relevant to the case in chief, Judge.
Objection sustained.
Was your ability to block all of that out part of your faith?
Objection, relevance.
Sustained.
Mrs. Anthony, were you able to compartmentalize whether Caylee was alive or not for almost 2 years?
Objection, relevance.
Judge, that has direct relevance to Miss Anthony being able to do the same.
Sustained.
On August 14, 2008, ma'am, you went to visit your daughter at jail.
Possibly.
Okay. Do you recall seeing an evidence and also viewing a videotape in which you explained to your daughter that that your husband, George, had blown up at the media?
I remember viewing the video. I'm not sure if that's the correct date, but yes, I remember the video.
Okay. And when you did that, there was an incident. Actually, you expressed that to your daughter, did you not?
Express what?
That your husband had just blown up at the media?
Yes.
And this was in response to a question that a member of the media had asked as to what his opinion was of the theory that Caylee had died by an accident.
Objection, hearsay.
Sustained.
This was in reference to a question as to an accident, was it not?
Objection, hearsay.
I'll rephrase, Judge.
Okay, objection sustained. You can attempt to rephrase the question.
Why did you tell your daughter about your husband just blowing up at the media?
Objection, relevance.
Relevancy?
Relevance, it goes to the actual way this child died. And knowledge, effect on the listener.
All right, questions from the media?
I'm not.
Objection sustained unless you can establish a foundation. She actually witnessed and knows how the child died.
Mrs. Anthony, you expressed that this was a new theory, was it not? Did you not express that in the jail video?
Yes.
In fact, you said the latest story, the new theory or the new story is that Caylee drowned in the pool.
Yeah, let me clarify. It wasn't a new theory. It was the media's statement regarding that. It wasn't a new theory.
Right.
Didn't mean to answer that. Thank you.
In fact, a month earlier, on July 16th, is when you had told Detective Melich about that, correct?
On July 16th, I mentioned to him that I found the pool ladder attached to the pool.
And throughout that time, while you were being questioned by law enforcement, you had also told police about the pool incident or the pool theory?
Yes, I mentioned to,
Sustained as the leading.
Did you tell the police numerous times about the pool ladder and your pool theory?
Relevance of her theory.
Sustained as to the relevance of dealing with theory. You can talk about what you told the police, but to a certain extent.
The statement on the jail video about this being a new theory is not true. It's not a new theory. You're clarifying it, is what I'm asking.
I said it's the latest story, I believe, from the media, or the theory from the media. It wasn't the latest. It wasn't the first time that we had discussed it with law enforcement. I was talking about what was portrayed in the media.
And Casey even said that after you had mentioned that George had just blown up at the media, Casey had even informed you, as what's in evidence, that she had heard. Correct?
She said she was aware that she had heard that our father had just blown up at the media.
And that wasn't true. That had just happened, correct?
I don't know if that's true or not. She could have heard it from someone in the jail.
You're aware that there are no televisions in the cells, correct?
I'm aware of that.
Okay. Now, I just wanted to clarify that out. There were numerous occasions where you had made law enforcement aware of the pool ladder incident, correct?
Correct.
And all of this information was being released in the course of discovery, was it not?
Object to the relevance.
Sustained.
I have no further questions.
Cross-examination.
Mrs. Anthony, good morning.
Good morning.
You recall when you related what the media was suggesting to your daughter, that her response to that was surprise, surprise.
That was regarding not her father blowing up at the media.
But the suggestion by the media that the pool had some involvement in Caylee's death, correct?
Correct.
The blowing up aspect of this exchange.
That last question, Judge.
Basis of objection.
Calls for speculation. How does she know what the reason why my client made that statement?
Response from the state.
She was the individual who directed the comment at the defendant, and in context, the defendant responded. So the witness was explaining that the response was as a result of her comment about the pool rather than the comment about blowing up at the media.
Your Honor, my response to that would be that they're talking about the media. Surprise, surprise means the media is at it again, not necessarily that it was her thought on the process.
Objection overruled.
When you came into the Orange County Jail that day, you were upset as well, because what the media was doing outside was suggesting to you that Caylee was deceased, correct?
Yes, the media was screaming at us and throwing out accusations like, what do you feel? How do you feel about your granddaughter drowning in your swimming pool? That was very upsetting.
Because at that time, you believed that she was missing and alive somewhere else.
Correct.
Thank you, that's all I had.
Redirect. Ma'am, you may stand down.
Thank you, sir.
George Anthony, George Anthony.
You may proceed.
Yes, sir. Mr. Anthony, I want to pick up where we left off during your testimony for the state. Do you recall when I asked you about a statement you made on July 24th of 2008 in reference to your law enforcement experience, where you stated, "We caught people out in the woods, in a house, and in a car"?
To counsel reading from a document that is not in evidence. This is not impeachment. This is not refreshing recollection.
Just bringing them up to speed of the questions.
Sustain, ask them a question, but don't read from a document that's not in evidence.
Do you recall the statement that we had discussed?
No, sir.
No, sir. Would it refresh your recollection if I showed you the statement?
Possibly.
You may.
I'd like to direct your attention to lines 1 through 5.
There's only one thing, sir, is I'd like to know what the question is prior to that, sir.
Do that. Do you remember making that statement, sir?
Absolutely, yes.
How did you know your granddaughter would be found in the woods 6 months later?
Assumes facts not in evidence, move to strike.
I think all of those facts are in evidence, Your Honor.
The fact that he knew is not.
And I'm asking
And
him
I
how.
object.
Overruled, you can answer the question.
Sir, you're asking about my law enforcement experience when I was doing law enforcement, not anything about my granddaughter Caylee or anything like that, sir. That is taken out of context by you, sir. That is going about my experiences and what I knew of human decomposition and what it smelled like. That's what that's about, sir. You're taking it out of context.
Your question, your statement was in relations to smelling human decomposition in the woods?
Objection. This is not impeachment.
I'm not impeaching him. I'm asking him questions.
And I would object to a prior statement being read. Relevance, not impeachment.
Approach and bring the statement. You may proceed.
Thank you, Your Honor. Mr. Anthony, did you tell the police that you smell human decomposition in the woods before?
Yes, sir. I had experience with that in law enforcement up in Ohio, yes.
Did you tell law enforcement that you smelled decomposition in a house before?
Yes, sir.
Did you tell law enforcement that you smelled human decomposition in a car before?
Yes, sir.
Now, getting back to the woods, the wooded area off Suburban Drive, during the months that Caylee was missing, you had actually walked that area. Did you not?
I didn't specifically walk in the woods. I walked a perimeter defense, and I can explain that if you'll give me a moment.
Please go right ahead, sir.
The reason why I did is because Sergeant John Allen came to my house with a stuffed animal of a cartoon character and asked if that had been in my home, if I had knowledge of that. And I told him no, and I asked him where he retrieved it from. He said at the end of the street. That's when I went for a walk.
And you were walking down that area during the 6 months?
Sir, I walked every street that I could in Orlando, specifically my neighborhood. Yeah, different times, sometimes to clear my head, sometimes to look up and ask what happened to Caylee, where she's at. Whatever I could do, sir, that's what I did.
Were you also not spotted in another wooded area?
Objection to the vagueness of the question.
Sustain, rephrase the question.
During that 6 month time period, were you in another wooded area, sir?
Objection to the vagueness of the question, other wooded area.
October of 2008, were you in a, not that wooded area, but a separate wooded area in Orlando?
Objection. Some wooded areas may be relevant, some may not. Without specifying what area, the question is vague.
Overruled.
Sometime in October, we were finding another location for our command center, the Kid Finders Network, our tent, things like that. Yes, I was down at the corner of Hoffner and Lee Vista in an area that I had called about through the county commissioner's office to see if that was vacant and if we could utilize that for our nonprofit Kid Finders tent, sir. That's the reason why I was there.
Okay. And you were going to put up a Kid Finders tent in the woods?
Adjacent to a street, sir, probably about 10 to 15 feet off the roadway, because there was a lot of activity, a lot of people coming by to draw attention to not only to my granddaughter being missing, but other missing children. That's what that was about.
Now, the statement that you made to actually, let me take it back. On July 15, 2008, you actually, the first night that law enforcement came to your home, you actually pulled Detective Melich aside and you told him that the car smelled.
Not on the 15th of July, no.
The 16th of July.
Sometime in the early morning hours when he first had arrived, absolutely, sir, I did.
Okay. And you did that privately?
I can't remember if it was privately, if there were other officers there. We had numerous people at our home in the morning. Did I talk to him about the car, about an Amber Alert, about so many things at night to try to find my granddaughter? Absolutely. I was hysterical. I was upset. I wanted answers. I demanded those answers to come to try to find my granddaughter, and I would still do that today.
The night the police were called, you were hysterical and upset?
Yes, sir, I most certainly was.
Okay. Now, after Yuri Melich had gotten back with Casey, you also pulled him aside again, did you not?
No, sir, I didn't pull him aside, no.
Did you go to his car before he left and told him that something had happened to Caylee and that Casey was lying?
Specifics on what him and I discussed, if I'm not mistaken, at the end of my driveway, probably about 6:30, 7 o'clock in the morning, that we had been up all night. I know that I did talk to him and ask him what was going on, what was progressing, what information did he have. I did all those kind of things, sir, as a concerned father and a grandfather, because I wanted some answers, and I demanded answers from him.
And you told him that something had happened to Caylee and Casey was lying.
Sir, definitely something happened to Caylee. She's no longer with us. And Casey was the last one that I saw with Caylee. 1 and 1 adds up to 2, sir, in my mind. And no matter how you're trying to spin it, I'm upset because my granddaughter is missing. I don't know where she's at. I was told that someone had taken my granddaughter, forcibly removed her from my daughter, or my daughter dropped her off at some house. I'm trying to put all the stories and information together, sir. Was I running on pure emotion and drive and demanding answers? That is my right as a father and a grandfather, and as whatever you want to spin it. Was I upset and falling apart at the moment? Absolutely. My family was being torn apart. And for you to say that I was doing something wrong, sir, you're wrong.
The witness commenting on counsel's questions.
Just listen. Yeah. Next question, Mr. Bass.
Yes, sir. Now, on July 24th, you went in and made this statement to law enforcement that you had smelled that car and you smelled human decomposition.
Yes, sir.
And you were sure of it.
I'm 100% positive.
Okay. And do you recall also telling them that Casey lives on the edge?
I possibly did. I don't remember the exact context. If I did, yeah, my daughter has a tendency to live on the edge. Yes.
Taking the statement out of context, not presenting the witness time, place, and persons present, and a chance to look at the statement.
Witness has answered that he recalls making that.
Did you have a full opportunity to answer the question that's presented to you, sir?
I feel comfortable with what I said, sir.
Pardon?
I feel comfortable with what I said to Mr.
Okay,
Bass.
thank you.
And you recall telling that law enforcement on July 24th, 2008, that Casey takes these lies as far as she can take them.
Objection. Time, place, persons present, and the portion of the statement.
Sustain, rephrase the question.
Do you recall telling law enforcement on July 24th, 2008, meaning Yuri Melich, John Allen, and Detective Shelley Mead, that your daughter takes things as far as she can take them?
I have page and line.
Page 29, lines 9 through 11.
Can I approach counsel and look at the context?
Yeah.
Objection, Your Honor. I'd ask counsel to read the question and answer in full under the rule of completeness.
I'm asking if he recalls making that statement, Judge, not impeaching him.
Your Honor, the rule of completeness, I believe, I don't want to make a speaking objection. The rule of completeness does require.
I bet you to do it on cross-examination.
Your Honor, if I may we approach, because I believe the rule
I know.
indicates it has to be done contemporaneously.
Mr. Baez, are you reading the whole question since I don't have the statement?
Yes, sir, I'll read the whole question.
Okay. I don't have the statement.
When asked, do you think the reason your daughter doesn't want to tell us what happened is for fear that what her mom might do, might say, I told you so, or something like that? Do you think that it would be so disappointing to mom and that's why she's taking this to the bitter end? And your answer was, now my daughter lives on the edge. You know, from all the lies, all the contradictions, and like my daughter takes things as far as she can take them.
If it's written down there, I said that, sure.
And in fact, during that whole interview, you kept talking about nothing but negative things about your daughter, weren't you?
Objection. The document speaks for itself. If counsel wants to put in for the jury to consider the entire statement.
I'm
for
asking.
For their own evaluation, the positive and negative, that's the appropriate way to do it.
I'm asking him if he recalls.
Overrule it, Mr. Brown.
Do you recall saying nothing but negative things about your daughter?
Apparently I did, sir. I was cooperating with the law enforcement any way I could to get some answers about my granddaughter.
And the very next day, you went and visited your daughter in jail.
That's possible. I'm not sure of all the exact dates. I know we didn't go as much as we wanted to.
And you've seen the videos of you seeing your daughter in jail, right?
Yes, sir.
You didn't say any of these negative things to her while you were visiting her, did you?
No, because I was trying to keep my daughter upbeat. I was trying to find out anything I could about where Caylee possibly could be. I was doing everything I could, sir, to keep her as happy and as comfortable as possible. I didn't want my daughter in there, but she is in jail.
The day before, you're throwing her under the bus with law enforcement, and the next day when you talk to her, you're being very nice, right?
Objection. Move to strike counsel's statement of his opinion.
I'll rephrase.
Sustain.
As you've testified, on the 24th, you're saying negative things about your daughter, and when you're on the video talking to her, you're saying nice things.
Again, sir, I was cooperating with law enforcement on one day, giving them information to help assist finding my granddaughter wherever she was at. The next day, going in and seeing my daughter, yes, I was trying to keep her upbeat because I don't want to see my daughter in jail, but unfortunately, she is in jail. And that's what you try to do. You try to talk to your loved ones, to your daughter, whoever it might be in there, to keep them upbeat so they're not in an emotional wreck when they're in a facility that they have no human contact with anyone.
So you were undercover of sorts?
No, sir, I was not undercover.
Amended. Move to strike.
Overrule.
You can answer, sir.
I was not undercover, sir. I was a father of a concern for his daughter and also for my granddaughter.
And you're aware that your daughter wanted to be bonded out, weren't you not?
Yes, sir. My daughter wanted to be out and try to help find her daughter, yes.
And the reason she couldn't get bonded out is because you would not want to put up the house as collateral.
Objection. Relevance.
Sustain.
Move to strike.
Motion to strike, granted.
Now, on October 14th, 2008, you went and testified against your daughter, did you not, before the grand jury?
Objection.
Not asking him any statements he made, just asking.
Your Honor, the fact that a witness is subpoenaed and compelled to appear.
Approach. Objection sustained. Next question.
Now, sir, You testified that on July 24th, when you spoke to law enforcement, you had stated that you were, I guess just now, that you were 100% sure that you had smelled human decomposition in the trunk of your daughter's car?
Yes.
Okay. And you've testified to that in this trial a couple times?
Yes, sir. I'm not going to lie about that.
Okay. Do you recall giving a deposition, in this case, on August 5th, 2009?
It's possibly that was the day. I'm not sure. I've given a lot of information at different times.
You remember coming coming to the deposition?
Sir, whenever I've been asked to arrive somewhere, I've been there.
I was there?
If you're talking about August 5th, 2009, yes, there was.
Mr. Ashton and Ms. Drain Burdick and Mr. George were there?
Yes, sir.
Okay. And you were placed under oath?
Yes.
And it was the same oath you took today?
Yes.
Do you recall being asked the question? And did you believe the smell?
We have page and line.
Yes, page 220, lines 5 through 14. Do you remember being asked the question?
Give counsel an opportunity to defend.
And did you believe the smell? Did you recognize that smell as being the smell of human decomposition? And do you recall giving the answer, sir? Not human decomposition.
Objection.
I knew it was.
Objection, rule of completeness, but it appears counsel's going to finish the answer.
Go ahead.
I knew it was decomposition there. I knew there was something that just didn't smell right to me. As I went around to the driver's side, opened the driver's door, took my breath away for a second. It really did. I mean, it's 90 degrees outside. The car had been sitting there for over 2 weeks. So, sir.
Objection. With the rule of completeness, I'd ask that counsel also read the answer at page 221, line 7 on the same subject matter.
I think
Read
that
it.
could be brought up.
Read it.
This is the answer to his question, sir.
Pursuant to 108.1, read the entire context.
I remember opening the driver's door, trying to vent out the car a little bit, and I remember it stuck the key in the ignition. As I did, I knew the car wouldn't start. As I told the guy, I said, well, it's probably out of gas. And the attendant that was there, he's the one that says, oh my gosh, this really stinks. And I said, yeah, let me stop. And then the question is asked, let me stop you for a second there. Well, do I have to keep reading other questions,
I
Judge?
request that counsel read through the answer which ends at page 22, line 6, because it is the same subject matter.
And I would request to conduct my direct examination and allow Mr. Ashton to do his cross.
Rule 1.8.1 requires it. Read it.
Okay. Let me stop. Then the next question is, let me stop you for a second before you go on to say to that. Okay. As you approached the car, did it come into your mind that the odor might be from decomposition of either your daughter or your granddaughter? Your answer, not at that point, sir. No, sir. It never crossed your mind? Mr. Ashton asked. Not at the initial point. No, it did not. Okay, go ahead. After I tried to start the car, I can remember the attendant saying how strong it was, and I said, yeah. I said, it's a little bit tough. I looked around inside the car. I couldn't see anything except my granddaughter's car seat and some shoes and other stuff. The car was messy inside.
I
Shall
would
I
ask the
continue?
counsel to complete the answer.
And I remember getting out of the driver's seat, walking towards the back of the car, and I didn't say it directly to this gentleman. I didn't say it underneath my breath. I said, please don't let this be my daughter or my granddaughter. As I opened up the trunk, the only thing that there was a bag full of garbage, a white bag and a tie on it, a twist tie. And there was an Arm & Hammer liquid detergent. I don't remember what size. I guess about the size, indicating there was a pizza box with maggots inside the box. I mean, in that bag, I remember that specifically because they were making a cracking sound like a hamburger on a skillet. I remember that specifically. I did not touch it. The attendant reached inside and says, this is your smell. He grabbed it, the trunk got shut, and walked over to dispose of it. Dispose of it inside the...
That's fine, Your Honor. That's the entire answer.
Okay.
All right.
So, sir, do you recall testifying in your deposition that you did not believe that the car was human decomposition?
Sir, that answer, I believe, speaks for itself. I remember being asked about this at the very beginning when I talked about walking up to that car and getting about 3 feet away from it and the smell that emanated from that car. I could smell it 3 feet away on the passenger side. When I opened up that car door, yeah, it smelled like decomposition, human decomposition. I will clarify that. If I didn't say that exactly at that deposition, at that particular point, that's because, again, sir, you have to, when you relive stuff over and over again that is traumatic in your life, you try to give the most complete answer that you can. Was it decomposition to me? Yes. Was it not my granddaughter or my daughter that I found in the trunk of that car? No, they weren't there. But there is a smell of human decomposition in that car, not the garbage that was in it.
And you testified that on July 24th, you told law enforcement it was human decomposition. August 9th, it's not, it's the trash. And today, it's human decomposition.
Sir, I didn't say that it was the trash. I did not say that. There was trash in the back of the car. There was maggots and stuff like that inside of that box or that plastic bag that I saw. I have been completely honest with that, sir, about my feelings and what I saw and what I observed. I'm not making anything bigger than what it is. I'm stating true facts of what I saw, what I observed, and what I went through that day and what my feelings were. Neither my granddaughter nor my daughter were in the trunk of that car, and I'm grateful for that because I don't know if I could have dealt with seeing them back there.
Now, sir, the explanation that you give during your deposition is clearly the trash, is it not? Would you like to look at it?
Sir, there's also a difference between trash and garbage.
And there's also a difference, sir, of saying it's human decomposition and not human decomposition?
I didn't say anything about not being human. I said decomposition. I'm going to clarify that again. I think I've done that very well. You're trying to take this joy of my life away from me, sir, and you can't do it anymore.
Would you like to see your
I'm going
statement?
to answer this to you, sir. The decomposition that I smelled in the trunk of my daughter's car on July 15th, 2008 at Johnson's Towing smelled like human decomposition.
Would you
To
like
me, sir, that's what it smelled like to me. And my knowledge of law enforcement and what I saw for 10 years of law enforcement gives me that opportunity to know what that is. I can close my eyes at the moment, sir, and I can smell that again. How dare you, sir, try to tell me that I did something differently than what I did?
And that is why you called 911 right then and there, right?
No, sir, I did not call 911.
That's why you drove that car home.
Sir,
Argumentative, asked and answered.
you are arguing with me, sir. I'm trying to be
Sustained.
calm.
Rephrase your question, Mr. Bass.
And then you went to work, sir, did you not? After smelling this smell,
Objection, argumentative, asked and answered.
Overruled.
then you went to work, sir, did you not?
Sir, after I knew that it wasn't my granddaughter or my daughter in the trunk of that car, I did get the car started. I left with my wife. We took the car home. Was I concerned about what was there and stuff like that? Sure. But then again, my emotions were all over the place that day. Did I go to work? Yes. I also explained in different times that I've spoke to law enforcement, to the prosecution, to you and things like that, of stuff that I can remember and stuff that I experienced on that day. I know exactly what I did, sir, and I'm not ashamed of what I did that day. There's no reason for me.
Strike non-responsive, Judge, to the question.
Overruled.
Now, Mr. Anthony, when you made this statement in your deposition, you were actually on a media blitz, were you not?
Objection, vagueness of the word media blitz.
You were going on multiple...
Rephrase the question.
Did you go on multiple media outlets and advocate the innocence of your daughter when you made this statement?
You're going to have to come up with dates, sir, and particular times and things like that.
August 2009, did you make any media appearances where you were advocating the innocence of your daughter?
Possibly I did, without seeing the context or things like that, sir. I didn't want to believe back then that my daughter could be capable of taking the life of her daughter.
Judge, I'm going to object to the non-responsive. I asked him a specific question. If he was on the media, making media appearances on behalf of his daughter.
The question was asked to a specific purpose or opinion being expressed, and the answer is responsive.
Next question.
Now, sir, in January, late January of 2009, you attempted to commit suicide. Did you, sir?
Yes, sir, I did.
Okay. And you even left a suicide note.
Yes, sir, I did.
And you expressed some guilt.
Objection. The best evidence of the document is the document.
Sustained.
I have the original mark, Mr. Baez, if you'd like to use it.
You expressed some guilt, did you not, sir?
Objection. The document speaks for itself. The best evidence of its contents is the document itself, and I have no objection to its admission into evidence.
I'll withdraw the question.
Sustained.
Were you hospitalized shortly after?
Yes.
And within a week, were you then again making further media appearances?
I don't remember what I did shortly thereafter being released from the hospital. Possibly I did. Not really sure.
And these media appearances that you were making them to advocate the innocence of your daughter.
Possibly without knowing exactly what was asked of me and how I answered that. I can't go back and say exactly what I said on that particular date and time, sir. I can't.
Do you recall being on 48 Hours?
Yes, sir.
And do you recall being paid $20,000 for that appearance?
You know, Mr. Baez, I have been nice to you. I have tried to answer every question to the best of my ability. And for what my wife and I might have retained from a news organization to bring awareness of my granddaughter, my daughter, and other missing children, that's what that article was exactly about. It had nothing to do with guilt or innocence or anything like that. We did that, sir, for self-preservations, to bring awareness for our children, for not only my granddaughter, because of how beautiful she was and the life that she meant to us.
I'm going to object to the narrative, Judge. Non-responsive.
Response to the question.
I did everything that I could possibly do to bring awareness of what my granddaughter meant to me, to my wife, and to my son, and to anyone else in this world that fell in love with her.
Was that the focus of the interview, or was your daughter and her innocence or guilt the focus of the interview?
Unfortunately, it just seems like any time that any of the media came around to us, more focus was always placed on my daughter.
The focus of the media is not relevant to this case.
And while you were advocating for your daughter's innocence, sir, did you make any appearances on the early show?
Possibly did, sir. I don't remember my exact itinerary or things like that. But then again, anything that we ever did media-wise was always to bring information about my granddaughter, other missing children, and I always spoke about that. I always did.
And all of these media appearances stopped when the allegations of abuse came up, correct?
I believe that, sir, was done through you, sir.
Sir, you recall finding out another way?
Objection. Relevance. Did we approach?
You may.
Mr. Anthony, you were questioned by the prosecutor in reference to ever molesting your daughter. Do you recall those questions?
No, sir.
You don't recall being asked by Mr. Ashton if you had ever molested your daughter?
You have to be specific, sir. When that might have happened, could have happened, you're not being specific, sir.
First day of trial. You were asked.
And a question, yes, sir, and I never would do anything like that to my daughter.
Okay. You know, of course, that sex with a child under the age of 12 years old is life in prison, don't you, sir?
Relevance.
Sustain.
You're aware of the possible penalties of child molesting, don't you, sir?
Objection. Relevance.
Sustain.
You, of course, would never admit to molesting your child, would you, sir?
Objection. Argumentative.
Overruled. He can answer the question if he can.
Sir, I never would do anything like that to my daughter.
My question is, you would never admit to it, would you, sir?
Sir, I would never do anything to harm my daughter in that way.
Only in that way.
Objection.
Sir.
Argumentative. Move.
Sustain.
Strike.
Now, sir, do you recall when we questioned you the first time in reference to the gas can?
Sir, I've been asked about those gas cans numerous times.
May I approach the witness, Your Honor?
You may.
So there's no misunderstanding of which gas can we're talking about, Mr. Anthony. That is your gas can.
What's the exhibit number?
Yes, sir. State's evidence 283. That is your gas can.
Yes.
And on June 24th of 2008, that gas can was missing.
Yes.
And you called the police.
Yes.
And you reported that gas can as stolen.
This gas can and another gas can that I had. 2 were taken.
And is that the first time you've ever reported gas cans stolen?
Yes.
And prior to that, you of course knew your daughter had used those gas cans many times to put gas in her car.
I had felt that way, asked her about it. Yes.
And you could even see the gas streaks on the side of the car.
Objection asked and answered in prior testimony. Repeating ground.
Overruled at this point, but let's get to the point.
If I had knowledge that my daughter had used this gas can or another one and placed it in gas that was inside of her vehicle, yes.
Okay. And you recall in your testimony for the state, when I questioned you, you stated that there was a gas can that you were shown in your deposition that did not have duct tape on it when you gave it to the police.
I don't believe I said that, sir.
Okay. Well, I'll ask you again, sir. When you gave the police that gas can, did it have duct tape on it?
Objection. It was given on 2 occasions. The counsel needs to specify which one.
Sustain, rephrase the question.
August 8th of 2008. The very first time they took those gas cans.
If I'm incorrect, counsel, it's August 1st. The
That's what I
photograph
said.
demonstrates that.
That's what I said.
I thought you said the 8th. You said the 8th.
August 1st of 2008, sir. Did that gas can have duct tape on it when you gave it to the police?
It possibly did. I don't remember. All I know is they came to my home with a search warrant and they took it from our father's shed that's on the south side of our home. I did not touch it at the time. They are the ones that reached in, said that this they were here for it, and took it.
And that was after you told them of this alleged argument you had with your daughter over these gas cans.
That's not an alleged argument, sir. It happened.
That's after this. Well, there's no one else that can testify to this, right? Except you?
Oh, my daughter was there, sir. Her and I had a disagreement over the gas cans being stolen on the 24th. That's when I
Was there anybody
made a
else
report.
there besides you and your daughter?
Myself, my daughter, and God knows the truth.
Okay. Now, anyone else on this earth, dog, anyone else you want to throw in there?
Objection, asked and answered, move to strike.
Sustained.
I'll withdraw it. Now, on August 5th, sir, of 2009, did you state, when asked the question, okay, when they took it, is it your...
Page and line.
Yes, 208,
Please.
line
Page,
9 through
line,
12.
date, who was there, and then
Yes, sir.
give counsel an opportunity to define it.
208, lines 9 through 12. Do you recall giving a deposition on August 5th of 2009, sir?
If you're talking about the one that the state attorney's individuals were there and you were court reporter, yes.
Correct. All those people were there, and you were placed under oath.
Yes.
And you were asked the question, okay, when they took it, is it your recollection that it had duct tape over the vent? And do you recall giving the answer, no, there was no duct tape on it on the vent? Do you recall giving that answer?
If that was at my deposition, sir, that's what I said.
And do you recall being confronted with a photograph, State's Exhibit 107, of that gas can?
Briefly, yes.
Okay. May I approach the witness?
You may.
And do you remember, sir, being asked, did you take the duct tape and put it on and take it off again? And your answer, no, sir, I did not do that. And do you recall Mr. Ashton asking you, but is it your testimony here today, under oath, is that there...
Page and line.
Same page.
What page?
Same page, lines 19 through 25.
What's the same page?
210, I'm sorry, Judge.
It's a different page. So 210.
Lines 21 through 25, actually.
Mr. Bias, the jury can't see Mr. Anthony, so kind of reposition the gas can.
The question being asked by Mr. Ashton, but is it your testimony here today, under oath, is that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on this can? And your answer, and you were asked, please answer out loud, yes or no. And your answer was, it was not on the can. Yes, it was not on that can. Do you recall giving those answers, sir, under oath?
Yes, sir, I did. You just read them. Yes, I'll agree.
Do you recall whether they, when police took that gas can on August 1st, 2008, did it have duct tape on it?
Well, sir, if I'm going by this photograph, apparently it does. But also, if I might expand on this gas can was taken a second time, I believe, probably 10 days or so after that, for a second time.
You were asked specifically August 1st, 2008, were you not, sir?
Yes, sir.
And you were shown that specific photograph?
I don't know if I was shown this specific one at the prosecutor's office that day, at the state attorney's office. I believe, sir, I was shown a bunch of different things that day.
Are you trying to say now that You were shown a different photograph of another gas can?
Sir, this gas can is the only one that's ever been talked about. I know I was shown, at least I believe, to my best recollection, that I was shown another photograph of this particular gas can. So that's answering your question, sir.
Now, sir, I'd like to show you the certified copy of your deposition. May I approach the witness?
You may.
In the back of that deposition, sir, there are the exhibits. Do you see those tabbed?
Are you asking me to open this?
I'm asking if you see the exhibits attached to the deposition. You'll see a tab.
Sure, I see something. See, you're not being specific on what exactly. There's a lot of exhibits there. So.
Sir, I'm going to ask you the questions. I'm asking you first, one step at a time, if you see the tabs where the exhibits are.
Yes, sir, there's numerous ones here.
Okay. Every photograph that you were shown in your deposition is on on those tabs. Can you search through, and I direct your attention to tab 1 and 10. But go ahead and search them all and see if there are any other gas cans that were shown to you at your deposition.
I'm looking at number 1, and I just looked at number 10. It's the same thing that you just have right here.
My question to you, sir, is can you check them all and make sure that there were no other gas cans shown to you that day?
I just did. There's only the first exhibit, which is exhibit number 1, and exhibit number 10 have pictures of the gas can, or photos of it.
Okay. So according to your testimony in this deposition, either the police planted that duct tape on that gas can or you were not telling the truth.
Objection. Is counsel quoting the deposition? If so, it can't be paraphrased. Improper impeachment.
Sustain.
Can I have just a moment, Judge?
You may.
When you had this alleged argument with your daughter, did the gas can have duct tape on it then?
No, it did not.
So after Casey was finished with the gas can and she returned it to you, there was no duct tape on that gas can.
I believe I've answered that on a few different occasions, sir. The day that my daughter tossed those or set them down very aggressively on the ground at the rear of her vehicle, okay, and she said what she said to me.
I'm going to object to the narrative and ask that the witness be instructed to answer the question. It was a yes or no.
Overruled. He's answering the question.
Go ahead, sir.
The day that my daughter gave me back these gas cans on the 24th, that was an alleged argument. It occurred. And it weren't really too much of an argument at that time. Sure, that was, maybe the voices were a little bit loud, but when she put those down on the ground forcibly and said, here was my exact words were, here's my fucking gas cans. I've said that before. This particular can right here did not have the little white plastic tab, the air vent on top of it. It was not there. And I also believe I'm not mistaken is, did I put a piece of tape or something on it maybe eventually? Yes, I did, because anything that is volatile as gasoline, when it has fumes or something in it, can be a problem, and I didn't want that to occur. If I happened to put some kind of tape or something on it, maybe I did. I don't remember. And for me, and for you to say now that I put this on or what I testify to, sir, I'll agree with what's in here. I will. I'm not trying to be belligerent. Or
Judge, I'm going to object
not.
and object to the narrative and move to strike.
May the attorneys approach the bench along with the court reporter. You may continue.
Yes, sir. Mr. Anthony, I just want to clear this final thing up, if I may. When Casey gave you the gas can on June 24th, 2008, according to you, the gas can did not have duct tape on it.
That's correct.
And you have also testified when the police confiscated that gas can on August 1st, 2008, after Caylee was reported missing, that it did not have duct tape on it?
If I'm not mistaken, sir, that I have said when it was retrieved from the south shed of my house, I did not touch it. If there was duct tape on it at that point, possibly I had put something on it. I also said that when I retrieved that, when my daughter gave it from her trunk of her car in front of me.
Sir, do you understand the
I'm
question?
trying to explain, sir. I'm trying to explain your question. You're not letting me answer.
I would object, Judge, to the narrative. I asked him a yes or no question. If he testified that when he gave this gas can to the police, it had no duct tape on it.
Question calls for a yes or no answer, sir.
Did you testify to that, sir?
I'll say no.
You didn't. So did the court reporter get your testimony incorrect?
Objection, the document is not in evidence.
Sustained.
Do you recall reading in your deposition where you said it did not?
Objection, the document is not in evidence.
Sustained.
Did you testify that it was not in your deposition?
Objection, asked and answered. He said no.
Sustained.
May I read the question again to the court to impeach the witness, Your Honor?
Your Honor, the witness has been asked about the statement, has denied he made it, and I believe under 90.612 that is the questions that can be asked and the answer given. If we could.
Go ahead, Mr. Baez.
Thank you, sir. When asked, page 210, lines 5 through 11, for court and counsel.
Read the question.
Sure.
Starting at line 3. You said page 210?
Yes, sir.
Question starts at line 3. And
Yes,
the
sir.
answer
Sure.
is from 8 through 11.
Yes, sir. Do you recall being asked, sir? Sure, and it is metal. So does it fall apart? All right. But is it? So it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent. And your answer, didn't have any duct tape over the vent. And when it came back to me, or the last time I saw it now, it had duct tape on it. It did. I did not put it on there. Do you recall giving that answer, sir?
I do now, yes.
And do you recall being asked? But is it your testimony? I'm sorry, page 210, lines 22 through 25. Through the next page through 10.
I believe counsel's already read that and the witness has acknowledged it.
Part of the impeachment.
Lines 22 through 211, line 1, the witness has already been asked and already acknowledged making the statement.
Sustained.
No further questions.
Cross-examination.
Mr. Anthony, on August 5th of 2009, you still believed that your granddaughter was killed by someone and it happened not in the custody of your daughter. Isn't that what you believed in August of 2009?
Yes.
And in that deposition, you and I sparred in much the same way you sparred with Mr. Baez here today.
Yes, sir.
And during that deposition, you were upset that you were being called upon to give testimony implicating your daughter in the murder of your granddaughter. That was your emotional state in August of 2009, correct?
Correct.
But today, you no longer believe that your granddaughter died in the custody of someone other than your daughter.
Judge.
Sustain.
You know, it goes to bias.
Sustain.
When you when you were giving the statement on July 24th, 2008, that Mr. Baez discussed with you at length, did you ever tell the police that you thought your daughter murdered your granddaughter?
I didn't believe that at that time, sir. No.
In January of 2009, a month or so after you, let me strike that. You learned in December of 2008 that the remains of your granddaughter were found. Is that correct?
Yes, sir.
What effect did that have on you when you learned that Caylee's remains had been found?
A deep hurt inside, tears, the whole gamut of just an emotional loss, a breakdown inside of me, and seeing what my wife and my son went through.
Up to that moment, had you held out the hope that Caylee would be found alive?
Absolutely. Every day from July 15th until the day we were told it was Caylee.
In January of 2009, you went, I'll give you a moment.
Need a break, Mr. Anthony?
No, sir, I need to get through this. I need to have something inside of me get through this.
Do you need a break, Mr. Anthony?
No, sir, I'm fine.
Okay.
In January, just let me know when you're okay.
I'm okay, sir.
On January 22nd of 2009, Mr. Anthony, you went and got a gun, didn't you? Counsel asked about this exact event.
Overruled.
Judge.
You may.
Well, I guess counsel should state the objection again. I'm not quite sure what the legal basis of the objection is. Counsel.
Yes.
Is that counsel has had no good faith basis for asking such a question when he knows that there was no gun involved in this suicide attempt.
My understanding of the events of this date are that Mr. Anthony went and got a gun, that he did so with the purpose, I believe he will testify, he did so with the purpose of forcing people who he believed might know something about who killed Caylee, specifically friends or boyfriends of the defendant, with the intention of forcing them to reveal what they knew and then taking his own life. It is revealed in the suicide note, and I believe he will testify that that's what happened. The defense has brought up the suicide. I do, so the court knows, intend for him to identify his suicide note, and in my case, I do intend to offer it because it shows that on January 22nd of 2009, this man had no idea who killed Caylee Marie Anthony. And it rebuts implications by the defense that he did. It's directly contradictory to the defense's argument, and it is proof. And I do have case law when we try to admit the note. But at this point, the circumstances of the suicide were raised by defense counsel when he asked the question about that event, and I believe I'm entitled to go into that.
Let me see the suicide note and let me see the case law that supports your position. Share those sites with the defense.
I made copies for everyone. And again, at this point, I'm not offering the suicide note yet. I would be doing it in my case in chief, but. The cases would be Nelson versus Seaboard Coastline Railroad Company, found at 398 Southern 2nd, 980. I have copies for court and counsel. The other case is a case out of Louisiana, Court of Appeals of Louisiana, First Circuit, Garza versus Tau Delta Fraternity National, found at 916 Southern 2nd, 185. And I have copies for the court and counsel. Your Honor, that the gun incident is prior to the suicide, so I will correct that with the witness. I do want to ask him about it because it is mentioned in the suicide note at page 4. It does go to knowledge, but I will correct that point.
Question be stricken and the jury instructed, Judge.
That's fine. I'll just ask it a different way.
Okay, I've reviewed the State's Exhibit M.A. suicide letter of Mr. George Anthony, and I've reviewed the two cases cited by the state of Florida. Mr. Baez, would you like a proffer of Mr. Anthony's testimony along this line?
I'm not exactly certain what the court's ruling. We are objecting to it, of course.
Well, what is the basis of, are you objecting?
To the admission, it's hearsay.
Which, his note?
I'm sorry?
The suicide note?
Yes, sir. And I don't think it falls under a dying declaration.
Mr. Ashton, your response as to hearsay?
Your Honor, it has two purposes, both to show the then existing mental or emotional state of the witness under
state of mind exception?
It is 90.803 3. And I believe that is the import of the Florida case I gave you, that a suicide note can be admissible to establish two things. The first is it establishes that at the time of January 22nd of 2009, it is significant that nothing in this document that this man wrote in contemplation of taking his own life, and he will testify that that was fully his intent, contains any statement of guilt or admission to doing anything to his daughter or his granddaughter. There's absolutely nothing in the note. So on the one hand, I would submit that the entire note is relevant because it does not contain. It contains many statements of guilt and regret for things that he has done wrong, but nothing about the particular offenses that the defense has accused him of in this case. On a separate matter, if the court does not admit the entire note, specifically page 3.
Let me see it, Madam Clerk.
Yeah. There is a specific issue raised in this case by counsel that Mr. Anthony knew in June of 2008 precisely what had happened to his daughter and where she was. The portion of page 3 that starts the following. She was so close to home. Why was she there? Who placed her there? Why is she gone? Why? For months, you and I, especially you, always questioned why. I want this to go away for Casey. What happened? Why could she not come to us, especially you? Why not Lee? Who is involved with this stuff for Caylee? Those specific statements show that in January 22nd of 2009, George Anthony did not know what happened to Caylee, how she died, or who killed her. It directly rebuts the implication by the defense, and it is admissible as a statement of then existing mental, emotional, or physical condition. Pursuant to the case that I've cited.
So it appears,
Mr. Byers?
It appears that Mr. Ashton is creating a self-serving exception to the hearsay rule, because that's all I heard as far as argument is concerned. And then he mentions that he was accused of something in June 2008. While that may be the theory of the defense, it was not brought out during any of the questioning of this witness. So I don't exactly, and again, that would still be self-serving. What is the purpose of this is to say he's innocent, and because he wrote it and took some some blood pressure medicine, therefore he can say he's innocent and a six-pack of beer. I don't think that.
The microphone is off.
That's completely the argument that Mr. Ashton said in his argument and appeal to the court.
Well, let me ask this question. You asked the question of Mr. Anthony. Did he attempt to commit suicide? Correct?
Yes, sir.
Did the state object? Okay. And what was the purpose, Mr. Baez, of asking the question about Mr. Anthony's attempt to commit suicide?
It's a fact in this case, Judge. He did attempt, however genuine an attempt it was, certainly that could be left for the jury to decide. Is this another plea for emotion? Could have been. Was it an outcry for attention? Could have been. Or was he really trying to take his own life? That, of course, only he can decide, or only he can say. But as to whether he has any, this gives him a free pass to write, I'm innocent, I'm innocent, I'm innocent, and go feel sorry for me because I drank a six-pack and some blood pressure pills. That I think.
Could it be that Mr. Anthony was so guilt-ridden that he wanted to take his own life?
Certainly
because
could have.
He had molested his daughter, and that he felt that law enforcement was closing in on him? Is that one of the impressions that one could infer or deduct from the evidence? A counsel could argue from the evidence?
Among many others.
Generally, a witness's state of mind at a particular time is generally not an issue. And I think it's the Louisiana case that says it is very rare that it becomes an issue. It looks as though the defense has made Mr. Anthony's state of mind an issue.
I would add to that, Judge, that of course the prosecutor did not object.
No, he didn't object, and
I was perfectly happy for counsel to open that door. I had no problem with it.
someone opened the door, and Mr. Ashton's trying to walk through it.
I would submit, though, that Judge, even without that, his knowledge was an issue even before that. By counsel's other questions, particularly his implications based upon where Mr. Anthony said he had smelled dead bodies, all of those comments have implied from the beginning a knowledge of what happened to Caylee that is specifically rebutted by this evidence, by the portions I cited. I do think the entire note rebuts the general implication, which I'm sure counsel will argue before this jury, that this suicide was somehow guilt-ridden. In fact, he even asked the question, didn't you express guilt in the letter, to which I objected to best evidence. So it's clear why Mr. Baez wanted this before the jury, to imply that there's some guilt for the crimes that Mr. Baez has accused him of, and this letter specifically rebuts that implication. And I submit should be admissible in its entirety.
Anything else, Mr. Baez? Okay. Are you offering this now, or are you going to offer this later on?
Well, Your Honor, I don't think it would be appropriate for me to offer it in the defense's case, so my intention was to have him identify it and offer it in my rebuttal case, because I assumed the defense would object to my doing it in their case, so that's basically how I plan to do it. I do plan to ask him about his thoughts, his feelings at that time.
Okay. The reason I asked, Mr. Baez, you're not going to let him introduce it in your case, are you? Okay. As long as that's what you're going to do, I think the door has been opened, but I really want to have some time to contemplate and read a few more cases in this area. But it is fair game on cross-examination to cross Mr. Anthony concerning the suicide, which was brought up on the direct by the defense. Okay, y'all need a quick 5 minutes before we bring this jury back in, because we will be forging ahead and
Yes, sir. Just
until
a
noon.
break would be nice.
I just wanted to make sure you weren't trying to do it now. That would mean that I would have to
My intention was
not
to do it in my case.
have a bite to eat, but study during the lunch hour.
I understand. Yeah, if we could take a 5-minute break, that would be it.
We'll take a 5-minute comfort break until 11:30 for the staff. Did you want a proffer of Mr. Ashton's cross-examination?
Sure.
Okay.
Require me to proffer?
Yeah.
All right. Mr. Anthony, in August of 2008, you went and obtained a firearm, did you not?
Yes, sir.
Why did you obtain the firearm?
2 reasons. Number one, I wanted to go get answers that I believe I could get from individuals that I felt in my mind at the time was responsible for Caylee.
You were going to force them at gunpoint to tell you information that you thought they had about what happened to Caylee based on what your daughter had told you.
Yes, sir.
What happened to that gun?
When I had retrieved the gun up, I think after about 2 or 3 days before I was allowed to take it out of the gun shop, an evening, I believe it was probably the 2nd or 3rd of September, I'm not really sure of the exact date. The Sheriff's Department and I believe a lady from the Corrections Department or something of that nature came to our house, came to Cindy and I's house, and because my daughter was home, told me that they had found out that I had purchased a firearm, and that was in violation of a firearm being in the home or alcohol being around someone who's incarcerated at my home, and the gun was taken from my car.
Before you had a chance to use it for the purpose you intended?
Yes, sir, was still had all the proper locks and mechanisms on it and things like that, yes.
Now, in January, on January 22nd of 2009, you went to a hotel in Daytona Beach with the intention of taking your life.
Yes, and I still have those feelings every once in a while, and even today.
Did you put pen to paper to leave an explanation for your wife and your family as to why you had chosen to take your life?
Yes.
May I approach the witness?
You may.
Show you state's exhibit. Actually, this is marked. This says defense MA. Is that correct? I mean, state's MA, I'm sorry. Is that the note that you penned on that day?
Yes.
Is that a true and accurate statement of your thoughts, your feelings, your intentions, and your knowledge as of that date?
Yes.
Had you also sent some text messages or communications to friends, family members, or your lawyer about what you were doing?
I know that I had sent text messages as far as what I exactly said, but I also know that I called my family, my sisters, my mother and father, basically to tell them goodbye, even though I didn't say that. I just told them not to worry. I wanted to go. I needed at that time to go and be with Caylee.
And you expressed that in the note?
Yes, I did. Because I believe I failed her.
Were you prevented from accomplishing your goal by the intervention of law enforcement?
Yes, if it wouldn't been for law enforcement, I wouldn't be here today.
That is a proffer of the testimony on those issues that I would offer.
Okay. All right. You have an objection to the testimony, Mr. Baez?
Oh, I'm sorry, there's one other I
Okay.
would add, just to be safe. Mr. Anthony, in that note, did you express some of the unanswered questions that were in your mind about what happened to your granddaughter?
I know I did. I don't know exactly what I wrote at that time. I do know that my penmanship throughout, at the beginning, at the end, I wrote it over many hours that night.
Those would be the questions I would ask.
Okay, and objections to that testimony, Mr. Baez?
Much of it is beyond the scope of direct examination. I certainly don't see the bearing of the firearm. None of that was testified to, and none of that has anything to do with this.
Witness about his knowledge during the periods of July, August, going into January. This is direct rebuttal to the implications of counsel's questions about this witness's knowledge of the fate of his granddaughter.
Ask that counsel point exactly to which question he believes, because I don't, or I don't know what he's talking about.
I rely on the court's recollection of the testimony on direct.
I think your microphone is off.
Yes, sir, I could cover the areas that I spoke with him. That was the areas of decomposition, his behavior with law enforcement at first, then his behavior on the jail video. Then I questioned him about his financial interests, his media appearances, his abuse, and his knowledge of duct tape and the gas can.
Questions were not limited in date or scope. Mr. Baez's questions covered a broad range of dates and topics.
Okay.
Mr. Ashton just finished making.
Well, the subject matter of the cross-examination deals with the issue of Mr. George Anthony's attempt to commit suicide. The issue of suicide was brought out in the defense's cross-examination of Mr. Anthony. Those questions are a logical progression dealing with the issue of suicide and the fact that the gun has some relationship to all of that. So the court will permit this line of questioning. As I said before, you can mark and have him identify the note. As you know, until it comes into evidence, you can't question him about the contents of the document, and the court will take this under advisement and look at this issue. Okay, let's return to jury. Stay recognized, President of the jury.
Yes, sir.
Defense, you may continue.
Mr. Anthony, in August of 2008, did you purchase a firearm?
Overruled.
Yes, I did.
What was your purpose in purchasing this firearm?
I wanted to get answers from people that I believed were involved with my granddaughter missing.
These were friends or associates of your daughter that you felt had some information that they were not giving up.
Yes.
And you were going to use that gun to force them at gunpoint to tell you what happened to your granddaughter.
Yes.
Now, before you had a chance to do that, it's correct, is it not, that law enforcement learned that you had obtained the gun?
Yes, law enforcement had found out from, I don't know who, and law enforcement came to my home with someone from, I believe it was the corrections department, I'm not really sure it was, and advised of the violation of a court order that a handgun and or alcohol are not allowed inside of our home when our daughter is there.
And since your daughter was home on bond, you were not permitted to have a firearm in the house.
That's correct.
And did they take the firearm?
Yes, they did. They had taken it the same day that I had brought it home. It was in the rear trunk or rear spare tire area of my vehicle.
So you never had a chance to use it for its intended purpose?
No, sir, did not. When I brought it home, it still had all the proper cables, key locks and things like that. No, sir, I never did.
Now, on the 22nd of January of 2009, this is approximately 6 weeks after the remains were found, did you travel to a hotel in Daytona Beach for the purposes of taking your own life?
Yes, sir.
Why, on that particular day, did you decide to take your life?
Why that particular day I picked out, I really don't know. All I know is my emotional state, even through today, is very hard to accept that I don't have a granddaughter anymore. But for that particular day, I don't know, it just felt like the right time to go and be with Caylee.
Did you call relatives and, perhaps not literally, but say your last goodbyes to them?
Oro.
I wanted to talk to my parents, my sisters. I know I called my son and my wife, and just somehow I was okay. Yes, to say goodbye for the last time.
Did any of them try to get you to tell where you were? Do you remember the content of the conversations?
No, because really, I was supposed to be going to a meeting that day, and I just decided that was the time for me to get away from all this, to spend time with Caylee.
As you sat in that motel room in Daytona Beach, did you put pen to paper and write a letter to your loved ones?
Yes, I did. And the letter itself, through drinking alcohol, taking pills, I started out to talk. I wrote this specific letter to my wife, Cindy, and just to tell her how I felt and how I didn't want to be in this world anymore.
Did you include in that letter questions that you had about what happened to Caylee?
Absolutely, exactly what I said in that letter, I really don't remember because I never really looked it over. All I know is there was numerous pages I wrote, and I know that my penmanship and something, I probably repeated myself numerous times, and all I know is I had to express what I was feeling and not feeling.
You wanted Cindy to know why you would be dead when she found the letter. Is that a fair statement?
Yes, because I couldn't tell her face to face.
May I approach the witness?
You may.
Show you state's exhibit for identification MA, the composite exhibit of positive 8 pages. Tell me, sir, if you recognize that as the letter that you wrote to your wife and family as you were preparing to take your life.
Yes, this is definitely the letter I wrote to Cindy and my family.
Thank you. May I approach and retrieve the exhibit?
You may.
Mr. Anthony, but for the intervention of law enforcement, you would not be here today, would you, sir?
Judge.
Basis of objection.
Relevance and asked and answered.
As they asked and answered, sustained, he's answered that.
In the proffer he did, Your Honor, I haven't asked him that in front of the jury.
Yes, he has, Judge.
If you'll look back and review, I think you'll find that.
He can answer.
That's correct, is it not?
Yes, that's correct.
No further questions.
Redirect on those issues.
Do you need a break, Mr. Anthony?
No, I'm fine.
Mr. Anthony, Mr. Ashton questioned you about sparring with him at the deposition. Is that correct? Do you recall that?
Yes, sir.
And this sparring even had Mr. Ashton questioning your truthfulness, did he not?
Objection to counsel's expression of his interpretation.
Sustain.
Move to strike.
Motion to strike, granted.
Do you recall Mr. Ashton reminding you of your oath, sir, during the deposition?
I'm sure he probably did, sir. I don't remember exactly that day.
And this sparring that went on was to try and pin your answers down on these gas cans, correct?
Objection to his conclusion about my intention.
Sustain, rephrase the question.
The questions had to do with the gas cans and the duct tape, did they not, sir?
I know there was some conversation that we had throughout the whole thing. I know there's different times we talked about specific things, gas cans, duct tape, my granddaughter, my daughter, a big gamut of things.
But the issues where you were sparring with Mr. Ashton about related to the gas cans and the duct tape, did they not, sir?
Well, to clarify sparring, that can be looked at two different ways. I mean, was there a verbal talk him and I going by, I could just consider verbal sparring? Yeah, I guess that would be considered, yes.
Now, Mr. Ashton classified my questioning with you about the gas cans and the duct tape as sparring. Would you classify that as well, sir?
Yes, I would.
Now, when you got that gun in August of 2008, your daughter was out on bond.
Yes.
She was under house arrest.
Yes.
And the first day that she came home, the entire family met with a person from the Department of Corrections having to deal with house arrest.
Yes.
And they explained to you the rules of someone being under house arrest, what you can't do and what you can't do, what you can do and what you can't do.
Correct.
And you were even given a list of what could be in the house and what couldn't be in the house.
Correct.
And on top of that, sir, you knew that you couldn't have firearms in that house.
Correct.
And you knew if a firearm was found in that house, that Casey would have to go right back to jail.
Correct.
And in fact, as soon as you drove up, within hours, Department of Corrections was there.
Correct.
And they almost took Casey right back to jail, didn't they?
Yes.
You never, prior to Casey being out on bond, went out and bought a gun, did you, sir?
Sir, my emotional state when I purchased that gun was to go get answers about my granddaughter, sir.
Judge, I'm going to object to being non-responsive.
Listen carefully to the question, Mr. Anthony, and answer the question.
My question to you, sir, is before your daughter got out on bond and had those conditions, you never went out and bought a gun.
No, I didn't.
This attempted suicide that you had, you went out and bought a 6-pack of beer. That was the alcohol you were drinking, right?
I don't know how much I purchased at that time. No, I don't remember that.
Was it a 12-pack of beer?
I don't remember.
Okay. It was beer.
Yes.
Okay. And the pills that you took were blood pressure medication, were they not?
Oh, there was a lot of different stuff that I'd taken with me, sir, that I just had gotten probably a week or so prior to that from a physician.
So you were drinking beer and blood pressure medication?
Sir, I had all different kind of stuff involved as far as nerves, something to keep me calm, whatever it was. I took a large amount of medication along with drinking beer.
Do you know what was recovered from your hotel room that evening?
You know, sir, I do not. I don't have a list in front of me. I have no idea.
Now, all of this was subsequent to 2 search warrants being issued at your home, correct?
Are you talking a specific date, a
Yes,
time?
I'll go back and explain. You had a search warrant issued on your home December 11th, 2008.
As far as I know, I did, sir. I wasn't there to accept it.
You had another search warrant issued, well, let me stop there. The search warrant of December 11th, 2008, law enforcement went through a lot of your things, did they not, sir?
Sir, they completely went through the whole house.
My question to you, sir, is they went through a lot of your things.
Sir, everything inside that house I have knowledge of. I've either purchased it or something. Yeah, it's my stuff. It's my stuff.
Specifically things that would be associated with you.
Everything in that house is associated with me.
I'm talking about your car.
Sure, my car is in the garage.
And they went through it.
Yes.
And you know that car was not in the search warrant.
Objection to relevance of whether it was in the search warrant or not.
Overruled at this point.
You know your car was not listed on that search warrant, right? And they went through it anyway.
Right, the whole house was turned upside down.
And they went through a lot of your personal things, not Casey's.
Sir, I wasn't there to see the search warrant. They went through the whole house.
And then they confiscated that gas can on December 11th.
I don't know. I don't know. I have no idea.
You were given a property list of what was confiscated on December 11th, were you not, sir?
As I've stated, I was not there when the search warrant itself was served on our home. I was not there. And exactly what was taken all the time, I do not have that much of a detailed memory to know exactly of, I believe it was like 70 or more items that were taken from our home.
And you're an ex-police detective, sir. You know that after executing a warrant, the warrant and all property taken is left at the home.
I would believe so if it was given to our attorney. I don't know what was all left behind. All I can tell you is our home was turned upside down.
And included, what they took was the duct tape on that gas can, correct?
Like I said, sir, I don't know exactly everything was taken from our home. I've answered your question, sir.
All right, let me ask you this way then, sir. When you came back from doing the Larry King show in California on December 11th, and you got into your home, did you see that gas can ever again in your home?
Well, sir, I never came back home to my home on December 11th, 2008.
Whenever you came back home, sir.
I'm answering your question, sir. I did not come back to my home on December 11th, 2008. I did not.
December 15th, whenever you came back.
Sir, I don't remember exactly what time we came home, what time, or anything like that. I've said this, and I'm going to say this again for probably about the 10th time, and I'm not trying to get upset, but you're making me upset. I can tell you right now is our house was in shambles. Our house was turned upside down. Things were flipped around our house. It took us days.
Judge, I'm going to object to the narrative. I've asked
out.
him a specific question. He's refusing to answer it and giving a narrative.
Overruled.
Okay. Mr. Anthony, you came back and you didn't go directly to your home. You went to the Ritz-Carlton, correct?
Sir, there was arrangements made for Cindy and I, yes.
Okay. And you stayed at the Ritz-Carlton for a couple of days.
Possibly, I'm not sure how many days it was.
Relevance of where they stayed.
Sustain.
Then you came back home before the second search warrant was executed.
Yes, sir, because I was there for the second one.
Okay. And you did not see that gas can or the duct tape in your home then, did you, sir?
On that particular date, on whatever day that was, I don't remember. I don't remember.
And you had in your possession all of the search warrant that was issued on December 11th, as well as everything that was confiscated during the first search warrant.
Sir, I don't know of all the, like I said, I know there was over 70 items taken.
My question
From
to you,
our
sir,
home.
is you had in your possession the items that were taken and the search warrant before the second search warrant was issued.
Objection to counsel's vague question, items, what items?
The property list.
Sustain, rephrase the question. It's 12 noon now, so
Yes,
we're
sir.
gonna break for lunch. They have some place.
Sure. Oh, I'm sorry.
And I have another matter at noon.
Yes, sir. I apologize.
Okay. All right, we'll be in recess for lunch. Please remember all of my previous admonitions. Is candidate upstairs yet?
Sir, we do.
And members of the jury, did you heed all of my previous admonitions during the recess? Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Mr. Anthony.
Hello.
I think where we left off, sir, was you had just gotten back from the hotel and you were at your home, and on December 20th, they issued a second search warrant of your home. Do you recall
Yes.
that?
Yes.
And you were home that day.
Yes.
And you got confrontational with the officers.
Yes.
And in fact, you had to be removed and sent to the back of the house to wait outside.
I was asked to step outside.
And you told Sergeant Allen, page 79, line 17 and 18 of Detective Allen's deposition.
Sorry, counsel wants to quote from someone else's deposition?
No, I'm going to ask him a question, if I may.
Oh, certainly.
You told Sergeant Allen, take your fucking minions and get out of my house.
Objection. Relevance.
Goes to the line of questioning, Your Honor.
Relevancy?
Goes to this individual's state of mind prior to committing or attempting to commit suicide.
I'm sorry, Judge, the date, I think it's the 20th. This is the month before.
There's a series of events that occurred prior to that, Judge.
Objection sustained as to that question and comment.
They then confiscated further materials, did they not, sir, from your home?
Yes.
And the next thing that occurred in this investigation was the state attorney's office issued a subpoena for your fingerprints.
Probably, excuse me, probably happens right around that time.
Counsel for that event?
Do you recall, sir?
Rephrase the question.
Yes, sir.
Put a time period in it.
In December of 2008, do you recall the state attorney's office issuing you an investigative subpoena for your fingerprints?
I'm sure they did. If it happened in December of '08, it possibly happened. I don't remember the exact date, but probably was.
Okay. And how many times have you had an investigative subpoena from the state attorney's office issued to you, sir?
Relevance.
Relevancy?
It's a significant issue in his life, Your Honor, a significant event.
Objection sustained.
That is not something you provided voluntarily, is it, sir?
What is that, sir? What are you talking about?
Your fingerprints. That is not something you provided voluntarily. They had to issue a subpoena for you.
Yes.
This is also approximately when, in December of 2008, or shortly in early January 2008, is when the video surfaced of Dominic Casey and Jim Hoover searching in the wooded area. Is that correct?
That's a possibility. I don't know the exact time.
Now, you at this time had noticed this video and become aware of it. Did you ever ask Dominic Casey what he was doing there?
Objection. Point in time, vague question, and hearsay. And relevance.
Rephrase your question as to time.
Yes, sir. In January, early January 2009, when this video first surfaced, did you go to your investigator, Dominic Casey, and ask him what he was doing in the woods?
Objection assumes the fact not in evidence that this video, quote unquote, surfaced in January of 2009.
Overruled, you can ask the question if you can.
I didn't know anything about a video being shot until it was released.
Which was early January 2009. Do you not recall, sir?
If that's when it happened, sir, then that's when it is. I don't really remember.
So my question to you is, did you go and ask Dominic Casey what he was doing in the woods?
No.
They had just found your granddaughter in that same vicinity, did they not?
I was told that in December, but I did not get that information from Dominic Casey. I didn't have a conversation with him on that.
Have you ever had a conversation with Dominic Casey asking him what he was doing in the woods 1 month before Caylee was found?
No, I never have.
Never sparked your curiosity?
Asked and answered.
Sustained.
After all of these investigations and search warrants and the subpoenas, sir, in early January of 2009, did you feel the walls closing in on you?
Objection. Argumentative assumes facts not in evidence.
Overruled.
I don't understand your question, sir.
You knew you were being investigated, didn't you, sir?
Objection. Assumes fact not in evidence.
He asked for clarification, Judge.
There's no evidence that Mr. Anthony was being investigated.
I think we heard evidence by the answers.
Rephrase your questions.
The pressure was getting to you, wasn't it, sir?
Objection. Leading. Argumentative.
Was the pressure getting to you, Mr. Anthony?
Objection. Argumentative.
Overruled.
From the beginning, July 15, 2008, I have always cooperated with any law enforcement, any FBI, any Florida Department of Law Enforcement, with you, sir, even, anyone that I could get information about my granddaughter or help in any way to bring her back home. I did that.
All of that cooperation ended on December 20th when you asked sheriff's officers to leave your home, correct?
Well, sir, I've answered this question numerous times, and I'll answer it one more time for you. The loss of my granddaughter, when I first knew that she was missing, and the ultimate time it was found out that she was no longer with us, that was a tumultuous time in my life, my wife's life, my son's life, and everyone in our family's life, to lose our granddaughter and a potential to lose my daughter.
My question, sir, was all of that cooperation ended on December 20th, 2008, when you instructed the police officers in a not so polite manner to leave your home. Isn't that correct, sir?
I was upset that day, sir. I was very upset. I have every right to be upset that day.
Did you understand my question, sir?
Yes, sir, and I've answered your question. I was upset that day.
So from there on out, you stopped cooperating once you found out they were investigating you.
Sir, there's been so many people been investigated because of this, besides myself. And I have opened myself up for every part of the investigation. I have nothing to hide.
Is the answer yes or no, sir?
If you'd like to ask me if it's a yes or no answer, I have completely cooperated, so that would be a yes.
Now, prior to the suicide, you were, the day of this attempted suicide, you were calling everybody. to let them know you were going to commit suicide.
Sustained, rephrase the question.
You called many, many people, did you not, sir?
Yes, I did.
You even called me.
Probably did. I don't remember if I called you or not. I probably did.
You wanted everyone to know long before you were about to attempt to commit suicide that you were going to do it.
Objection. Leading argumentative.
Sustained,
As to leading, sir?
argumentative.
And after this alleged attempt, sir, you immediately left the hospital and went to Putnam County to be on television, did you not, sir?
No, sir.
Did you not go and have several media appearances shortly within 24 hours of leaving the hospital?
Not from leaving the hospital, no, sir.
Did you have, well, how long before you went and made media appearances?
If you can give me a particular date or an instance you're talking about, sir, I can probably give you all the information you want.
Sure, January 22nd is the day of this alleged attempt, is it not?
Well, sir, it wasn't an alleged attempt. It was an attempt on I tried to take my own life. So
Okay.
that's not alleged. That happened.
Okay, now, after that date, when's the next time you were on Fox News?
I have no idea, sir. I have no idea.
Was it within 48 hours?
I don't believe so.
And answer, Judge.
Sustained.
I have no further questions.
Just a couple more, Mr. Anthony. You traveled to California with your wife to be on a national show hosted by a gentleman by the name of Larry King just before the remains were found. Is that correct?
Yes.
And in fact,
I'm going to object. This is beyond the scope of redirect. He's discussing issues of December 11th.
counsel
Or
specifically asked
December
about
10th, I should say.
Larry King. And the purpose of that media appearance was to publicize the disappearance of your daughter and the plight of other missing children. That's what you talked about.
Well, the disappearance of my granddaughter, yes, and how it's affected our lives.
And did you learn of remains being found before you left California or when you arrived?
In the morning, just prior to boarding our plane, we had gotten phone calls. I can't remember if it was Mr. Baez or not, or the Sheriff's Department, or a conjunction, one right after the other, but Cindy got some calls, and they had found a small child.
When you arrived back in town, you were whisked to the Ritz-Carlton, correct? Someone
Yes,
picked you up
sir.
and took you there.
It was, when we arrived, within probably an hour after we had settled on the plane, we were taken to eventually what I saw was the Ritz-Carlton, yes.
You didn't arrange that or request that. Someone had done it on your behalf, and you were taken there.
Yes, we were taken there, yes.
Did you have at least a small window of privacy with your wife to deal with the news that you had just heard?
On our plane ride back, we did have a little bit of time wondering what was going on. That's a 5-hour flight. When we arrived and we were told we couldn't get off the plane till everyone was off of it, and we had Orlando Police Department, a numerous amount of people holding us back to get off, the only time that Cindy and I could really comprehend what was happening with us is when we were in a vehicle leaving the airport, and we're both just completely just falling apart, wondering what's going on, what's next. To say what our exact emotions or thoughts were at that time, we were just trying to just console each other. Hold on. That's all we had was each other.
Were you all communicating with Mr. Baez during that period of time?
The only time I can remember we talked to Mr. Baez was later that evening.
In fact, you and your wife had dinner at the Ritz-Carlton that night with Mr. Baez. Isn't that correct?
Yes.
May we approach?
You may. You may proceed.
Mr. Anthony, during the period from July 16th through December the 11th, Mr. Baez asked you about how you cooperated with law enforcement, and you said that you did.
Yes.
Did you also cooperate with Mr. Baez?
Yes.
Did you cooperate with anybody that you thought had the remotest chance of helping you find Caylee?
Yes, sir. I would take any help that I could get.
And January 20th, that was the day after it was declared that the body from the woods was in fact Caylee,
I
isn't
just
it?
want to object. Assumes facts not in evidence. It's January 22nd,
Sorry.
not the 20th.
I'll rephrase.
Sustain.
It was December the 19th that the ID was confirmed. Is that correct? I may have said January by mistake.
Yes, sir. It was probably the 19th or 20th, yes.
So what I'm getting at is this anger that you were expressing toward law enforcement was the day after you had final confirmation that, in fact, your granddaughter was dead.
Yes.
No further questions.
Read it right.
Mr. Ashton had asked you that you were taken from the car to the Ritz-Carlton. Is that correct? Do you recall that?
It was either car or SUV. That was irrelevant. That's the irrelevant one. But yes, we were taken from the airport to the Ritz-Carlton, yes.
That wasn't by law enforcement, was it?
Whoever it was, I really don't know. I honestly still don't know to this day.
The people who paid for you to stay at the Ritz-Carlton was Good Morning America, wasn't it, sir?
Relevance.
This was brought out by counsel.
Relevance.
I don't know exactly who paid for it. I really seriously don't.
You have no idea. You got to stay at the Ritz for 3 days, and you have no idea who was picking up the tab.
Objection asked and answered.
Sustain.
And did you have to do anything in exchange for that stay, that 3-day stay at the Ritz, like grant any interviews?
No, sir.
Have you, since then, been on that program?
I don't believe I was ever just on Good Morning America. No, sir.
You've never been on since then?
I don't believe we were ever, I just was on Good Morning America. No, sir. I don't believe so.
No further questions.
May Mr. Anthony stand up?
As the state's concerned, yes, sir.
Thank you, Mr. Anthony. You may stand down, sir.